Good morning, everyone. Thank you so much for joining us today. My name is Melinda Fosshat, and I'm the Symposium editor for the Kansas Journal of Law and Public Policy. And at this time, I would just like to extend a warm welcome to all of our panelists who will be participating in today's very important event. And I would also like to thank Professor Peters, Na-Young Kim, and PrivacyPraxis for hosting this year's symposium. Before we get started, I would like to draw everyone's attention to the bottom right-hand corner of your screen. You will see a box labeled Q&A. That is our questions and answers box where you can submit your questions at any time throughout the symposium. I will point out that the panelists will not be addressing questions during their individual presentations, but we will address questions during the panel discussions. I would also like to mention that scholarship associated with today's presentations will be published in an upcoming issue of the Kansas Journal of Law and Public Policy. And today's presentations will also be recorded and posted to our KU Law YouTube channel. So please check that out at a later date once that's posted. Okay, so at this time, I would like to turn it over to Dean Stephen Mazza. He's the dean here at the University of Kansas School of Law. Welcome, Dean Mazza, and thank you so much for joining us today.
Thank you very much. Good morning, everyone. Welcome. I want to start by thanking Melinda Fosshat, who is this year's symposium editor for the Kansas Journal of Law and Public Policy. Melinda, along with Audrey Nelson, who is the journal's editor-in-chief, and the entire board have done a really great job of organizing this year's event. So our thanks to them. I also want to recognize and thank the two faculty advisors for the Journal of Law and Public Policy, Professor Rick Levy and Professor Leah Ewell, for working with the students and giving them some really great advice. This year's symposium, Post-Pandemic Privacy, Health, Data, and Dignity, is of importance nationally, regionally, and locally. It is a topic that is worthy of a publication that from its very inception has been devoted to addressing important public policy issues. The organizers have put together an incredibly impressive panel of speakers from law schools around the country. I won't take the time to introduce each one of them at this point, but on behalf of the faculty of the law school and all of our students, I do want to thank all of them for participating in today's event. And I suppose I will single out our keynote speaker, Kimberly Mutcherson, if only because she is a dean at another law school, and I just think it's wonderful that she has enough time in her busy schedule to participate. So thank you. Special note of thanks to Professor Jari Peters, who was instrumental in putting together today's program. Professor Peters is a faculty member at KU Law School. She is also a faculty associate at the Berkman Klein Center for Internet and Society at the Harvard Law School. And she is also the creator of PrivacyPraxis, which is co-sponsoring today's event and which held its inaugural symposium here at the KU Law School last year. Incredibly grateful to Professor Peters for her work on today's program. She is a wonderful colleague who is bringing a lot of positive national attention to the school. Today's event is funded in part by the Judge Timothy Nelson Stevens Fund. This was an endowed fund created by the late Kate Stevens in memory of her father, Judge Nelson Timothy Stevens, who graduated from the KU Law School back in 1875. And who was also a district judge for Kansas. You know, it's been 146 years since Judge Stevens graduated from the law school, and we still honor his memory and extend our extreme gratefulness to the family of Kate Stevens for their generosity over the years. Again, thank you all for joining us. And I will now turn the program over to Professor Peters.
Good morning, everyone. Thank you so much, Dean Mazza. We're so happy to have you all participate in our symposium today. I have the honor of introducing our esteemed keynote speaker, Dean Kimberly Mutcherson. But before I do that, I want to express deep thanks to the symposium and journal leadership, including Audrey and Melinda, the journal advisors, Professors Ewell and Levy, and our Dean, Stephen Mazza. Dean Mazza has provided unwavering support to PrivacyPraxis, and we hope to continue to bring programming and additional contributions to Green Hall with his guidance. I also want to send a special thanks to all of our speakers who have graciously agreed to participate in our symposium, including two of my colleagues and friends from Seton Hall Law School, Professors David Opterbeck and Jake Ellberg. Finally, I want to thank Dean Kimberly Mutcherson for not only agreeing to deliver our keynote today, but for also being a wonderful example to all of us in the Legal Academy. Dean Mutcherson actually was a speaker at one of the privacy conferences that I held at Seton Hall Law School, along with Jake Ellberg some years ago. So it's nice to be in their company again today. So by way of introduction, Dean Kimberly Mutcherson is the co-dean and professor of law at Rutgers Law School in Camden. She is the first woman, the first Black person, and the first member of the LGBTQ community to have this role at Rutgers Law. Dean Mutcherson is a reproductive justice scholar whose work focuses on assisted reproduction and abortion, among other topics. Cambridge University Press released her edited volume, Feminist Judgments, Reproductive Justice, rewritten in 2020. Dean Mutcherson was a co-recipient of the 2022 M. Shannara Gilbert Human Rights Award for the Society of American Law Teachers and the 2021 Association of American Law Schools inaugural Impact Award. As one of the creators of the Law Dean's Anti-Racist Clearinghouse Project. Also in 2021, the Rutgers Law School Black Law Students Association gave her the Champions of Social Justice Award. She received the Center of Reproductive Rights Innovation and Scholarship Award in 2013, a Chancellor's Teaching Excellence Award in 2011, and the Women's Law Caucus Faculty Appreciation Award in 2011 and 2014. Dean Mutcherson has been a senior fellow sabbatical visitor at the Center for Gender and Sexuality Law at Columbia Law School and a visiting scholar at the Center for Bioethics at the University of Pennsylvania. She received her BA from the University of Pennsylvania and her JD from Columbia Law School. She also received the Kirkland and Ellis Fellowship for postgraduate public interest work upon her graduation from Columbia. Prior to joining the faculty at Rutgers, Dean Mutcherson was a consulting attorney at the Center for Reproductive Law and Policy, now the Center for Reproductive Rights, and a staff attorney at the HIV Law Project. Please join me in welcoming our keynote, Dean Mutcherson.
Awesome. Well, thank you so much for that incredibly lovely introduction, Professor Peters. It's always nice to sort of hear yourself described in a way that feels really good. So I appreciate that. So let me go ahead and get my screen share going so we can get started. Terrific. So good morning to all of you. I am, as I said, really excited to be here. I hope it's showing the right thing to you. Can someone just give me a thumbs up to say that it's actually showing my PowerPoint slides and not my Microsoft Word?
Yes, we can see your PowerPoint.
Okay, perfect, thank you. So many thanks to everybody at KU, to Melinda and the other folks who put together this event. I know how hard it is to put together events, virtual or not, so I know a lot of work went into this, so thank you for allowing me to participate. And thank you to all of you who are here. It's a huge pleasure to be here with you, even in this virtual format, which continues to not be my favorite because I'm one of those people who really feeds off the energy of the crowd. So I'm going to ask you, if you will, to try to send me some good vibes through the internet during the time that we're together this morning. So as you heard in the introduction, my teaching and scholarly work really focused on family law, bioethics, health, and reproductive justice. And I'm especially interested in assisted reproductive technology and abortion, but I'm really broadly interested in law and policy related to reproduction and parenting. And of course, much of the law of reproduction and parenting in this country centers on the idea of privacy. So while I would never call myself a con law scholar writ large or an expert on privacy law writ large, I think a great deal about the implications of privacy for the issues that I have focused on for the 20 plus years that I have been in the legal academy. And if you care about the law of privacy as it pertains to our reproductive lives, frankly, there's a great deal for us to be worried about right now. So let me tell you what I'm going to do in the time that I have with you this morning. Oops, there we go. So first, I want to frame reproductive justice because that is the way that I think about the world and the way that I think about these issues. I want to talk about how the pandemic has impacted reproductive justice and the right to privacy. And then I want to end with what the end of Roe portends for the future of reproductive privacy. And I say the end of Roe with a fair amount of certainty because I think it's better to be fatalistic a little bit and sort of plan for the future than imagine that we're going to get a particularly positive outcome from this court if you believe that Roe was correctly decided. As I talk today, I'm going to use the words women and pregnant women. I'll also use pregnant people and people capable of pregnancy because cis women, of course, are not the only people who get pregnant, but there are lots of places in my work where the category of woman and the way that women have traditionally been treated in this country really matters, particularly Black women. And I don't want to forget that. So I won't always be using gender neutral terms. So as I said, I really want to start from the beginning so that we all have the sort of same sense of what I'm talking about when I talk about reproductive justice. So reproductive justice is a movement and a term that was coined by Black women in 1994 who were interested in articulating principles of a movement that went beyond reproductive rights and a pretty narrow focus on abortion, which had really been what the mainstream reproductive rights focused on and choice, and really switch that focus to issues that were especially salient to marginalized women and centered the experiences of those women in their movement and ultimately in the theory of reproductive justice that flows from that. So reproductive justice encompasses a woman's human right to decide if and when she'll have a baby and the conditions under which she'll give birth, to decide if she won't have a baby and her options for preventing or ending a pregnancy, and then to parent the children that she already has with the necessary social supports in safe environments and healthy communities and without fear of violence from individuals or from the government. So just hearing those words should give you a sense that reproductive justice is much more expansive than a reproductive rights paradigm. So as I said, it's human rights based, it is intersectional in the true sense of that word. And what I mean by that is that it focuses on the experiences of Black women for whom sitting at that intersection of Blackness and being female means that our experiences of discrimination and oppression aren't simply about being Black or being female, but often come from that very specific experience at sitting at that intersection of those two identities. It is rooted in the experiences of women of color, which means that reproductive justice doesn't center the experiences of white women, but places the experiences of Black women and other women of color who sit at the furthest margins of being protected, at its center, because what we know is that when we act to protect white women, lots of women often get left out of that protection. When we act to protect women of color and Black women and other marginalized women, white women often benefit from that, and in fact often benefit more than women of color. And then finally, reproductive justice recognizes that reproductive oppression is experienced differently for people of color and other people from marginalized communities. So again, as I said, it should be obvious that RJ is much more expansive than our general reproductive rights discourse. It encompasses environmental justice, criminal justice reform, education reform, healthcare reform, the end of income inequality, the expansion of voting rights, right? All of these things. And so as a person who is an RJ scholar, I am really concerned with how the law acts as both a barrier and a burden to reproduction and parenting to many women based on socioeconomic factors like race, income, education level, disability status, immigration status, histories of incarceration, and more. And as well, I'm interested in the ways in which US law and US lawmakers devalue reproduction for Black people and people of color in general in this country. And the examples of that, particularly for Black folks, are legion, right? Everything from the abuse of enslaved women to decades of forced or coerced sterilizations in this country, to a modern child welfare system that punishes poverty much more than it protects children. So that's the reproductive justice paradigm. And let me shift now to talking about RJ within the context of law. So when you hear all of the things that I said are part of the reproductive justice paradigm, I'm sure it's obvious to all of you the extent to which law can and does support RJ is often rooted in the right to privacy as it's been articulated by the Supreme Court. So from the 14th Amendment and then other amendments, of course, depending upon which cases you happen to be reading at the time. And there are really three core constitutional rights that are involved when we talk about reproductive justice: the right to procreate, the right to not procreate, and the right to parent our children in safe and healthy environments. So we are talking about cases like Meyer versus Nebraska, Prince versus Massachusetts, Skinner versus Oklahoma, Griswold and Eisenstadt, Roe, and Planned Parenthood versus Casey. The cases that protect our right to the care, custody, and control of our minor children, our right to procreate, our right to access birth control, both for married people and single people, the right to terminate a pregnancy, and the right to marry interracially or to marry a same-sex partner. And now, importantly, and we all know this because we're law-related people, none of these rights appear as such in the text of the Constitution. So we've got reproductive justice, and then we've got this sort of broad range of law that supports at least the idea of reproductive justice, even if it doesn't evenly protect that idea across communities, across time, and across place. So everything that I've said so far is pretty standard in terms of an opening, and hopefully isn't too controversial. And it's all really foundational to the work that I do as a reproductive justice scholar. And it's really sort of a mainstay of the talks that I usually give, and the talks certainly that I gave prior to March 2020, when, as we all know, the world went into major upheaval. But I am giving this talk in 2022 when, despite those who want to declare that COVID is over because they are over it, we are still living in this very devastating and difficult timeline. Over the last several years, we have really leaned into the ways in which our COVID world was supposedly not normal. And obviously there were lots of ways in which that was true, right? Moving through the world wearing a mask, social distancing, moving all of our law schools online, right? Those were things that were not normal. And yet so much about the world that we have lived in during COVID is stunningly ordinary, predictable, and normal, starting with the constant reminders of the extremely precarious state of Black people and Black and brown bodies. So remember, RJ says that every mother, every parent deserves to be able to raise her children in safe and healthy environments. But we know that across a whole host of measures, Black people are less well off in this country than white people, whether it is disproportionate representation in the child welfare system and in our prison system, whether it is about insurance or access to medical care, whether it is about access to education. There are so many different measures by which we can say the experience of being Black in this country is substantially different than the experience of being white. And so given that, there's nothing surprising about the fact that there has been a wildly disproportionate impact of COVID-19 on Black and Brown communities, marked by the painfully high number of infections and deaths. And this data, you could look at it either in 2020, or you can move to 2021 and 2022, and we're still going to see the same things, right? Which is that Black and Brown folks were dying in numbers and getting sick in numbers disproportionate to our reality in terms of how many of us are a part of this country. And of course, the impacts of a pandemic are going to be economic and psychological as well. And we've had research on that also, right? That there are, that the experience of economic challenges is substantially more for people of color, that women in particular are experiencing particular emotional hurdles and emotional pain as a consequence of the pandemic, and that also the mental health concerns for Black and Latino respondents tended to be higher in talking about how the epidemic has impacted them. And again, none of this should be surprising, and none of it should be something where we say, how could that have happened? There are lots of other things that we have seen over the last few years as well. One is watching poor women and poor people in general who are already on the brink of economic disaster in whatever the best of times are, forced to continue to engage in low-wage work because suddenly they were essential. So we saw, women and others who were earning minimum wage, who had to brave public transportation, who had to deal with the disappearance of childcare in many cases, employers with inadequate or no PPE, belligerent customers, and all of this to bring home paltry paychecks, which didn't even cover their expenses. We had children who lost access to food, to dental care, to mental health services, as all of those things collapsed when public schools closed, because that is the venue through which so many low-income children receive a wide range of services that are necessary for them. We watch states, particularly, but not only in the South, doubling down on their voter suppression efforts as the Voting Rights Act sits decimated and unprotected by Congress. And through it all, we watch Black mothers continue to bury their children too soon in a country where maternal and infant mortality rates for Black women far outstrip those of white women, but also in a country where the violence of law enforcement is directed at Black bodies substantially more than we see it directed in other communities. And so a long line of Black mothers who mourn children who are gone too soon. Women like Mamie Till, the mother of Emmett Till, Gwen Carr, the mother of Eric Garner, Leslie McSpaden, the mother of Michael Brown, and Sabrina Fulton, the mother of Trayvon Martin. We continue to watch the suffering of Black mothers in this country who haven't been able to protect their children from violence in their neighborhoods, from the school to prison pipeline, from police brutality, from preventable illnesses, from medical neglect within our healthcare system, and more and more and more. And then, of course, as I said, the mothers who go home without babies and the babies who go home without mothers in a country where Black infant mortality where Black infants are 2.3 times more likely to die than white infants, and Black women are 2.5 times more likely to die from childbirth than white women. So make no mistake that in this country, right, which calls itself the greatest country in the world, and continues to have one of the highest rates of maternal morbidity and mortality in the world, pregnancy and childbirth can still very much be a death sentence. The women who were subjected to sterilization without their consent or knowledge because some physicians feel like they know better than we do what should be happening to our bodies. Sorry, I'm missing. There we go. That's the slide that I wanted. And some of you may remember, and everything seems like so long ago within the context of the pandemic, but there was a nurse named Dawn Wooten who was a whistleblower who talked about sterilizations that were happening on women who were being held at an ICE detention center down in Georgia. We talked about it for about 5 minutes, and then it disappeared from the news cycle. But this, of course, is part of a very long pattern of forced sterilizations and coerced sterilizations against women of color in this country. And then finally, the politicians who used the pandemic to cut off abortion access by declaring abortion services to be non-essential, and then denying access to telehealth for medical abortions. All of this in a pandemic where all kinds of medical care had been shifted over to telehealth, and yet the access to being able to terminate a pregnancy was not. And we well know that making it harder to get an abortion is very much an attack on Black women who disproportionately have abortions in this country and who bear the brunt when forced to carry pregnancies to term that they otherwise would have terminated. So I've said all of these depressing things, and now I want to talk about the implications for privacy here, right? What does any of this have to do with privacy? And I would say everything, or at least a lot. The right to privacy in this country is obviously imperfect, because if it were being doled out in a reasonable and a fair way, we wouldn't see the kind of inadequacies and the kinds of unfairness that I have already articulated here. But even as imperfect as it is still something. And right now it is deeply at risk at this time in our history. Everyone here, no doubt, knows that the right to abortion that was articulated in Roe versus Wade as significantly modified but not overruled in Planned Parenthood versus Casey is on its last legs. And we will know its fate in June when the court makes its decision in Dobbs versus Mississippi, the case that is challenging Mississippi's 15-week abortion ban, which is unquestionably unconstitutional under Roe and under Casey. Now, if you listen to the Dobbs argument, you can see why the concerns about privacy should really be prominent here, because that conversation was not just about abortion and the briefs weren't just about abortion. So I'm going to give you a couple of examples of what I'm talking about here. So in the Dobbs argument, Justice Sotomayor asked Solicitor General Stewart, who was arguing on behalf of Mississippi, whether overruling Roe would lead to the loss of other constitutional rights that were similarly rooted in privacy, like the right to marry interracially, so Loving versus Virginia, or to marry a same-sex partner, Obergefell, or the right to access contraception. And in response, S.G. Stewart claimed that these rights were not at risk. And here's what he said. Here's how he answered that question. I think the vast run of those cases, and some mentioned from time to time, are Griswold, Lawrence, Obergefell. These are cases that draw clear rules. You can't ban contraception. You can't ban intimate romantic relationships between consenting adults. You can't ban marriage of people of the same sex. Clear rules that have engendered strong reliance interests and that have not produced negative consequences or all the many other negative stare decisis considerations. He also continued, and I won't talk about this, but I want to at least put it out into the world. He continued, quote, I'd add none of them involve the purposeful termination of a human life. So those two features, stare decisis and termination of a human life, Your Honor, puts all of those safely out of reach if the court overrules here. Now, as an aside, of course, we are one of the countries that continues to put people to death at the hands of the government. So the idea that the only situation in which we're talking about the termination of life is an abortion is a little odd of an argument to make. But moving past that, the SG's claim in front of the court is really belied by the words of some of the amici, who clearly understand and are eager to see what other havoc can be wreaked on the rights of marginalized communities should and when Roe falls. And in so doing, undermine the entire canon of the constitutional right to privacy. So I want to show you an excerpt from one of the amicus briefs, and this was an amicus brief from Texas Right to Life in Dobbs, and that brief repeatedly refers to Roe and all of its progeny as lawless. And so here's the quote. This is not to say that the court should announce the overruling of Lawrence and Obergefell if it decides to overrule Roe and Casey in this case, but neither should the court hesitate to write an opinion that leaves those decisions hanging by a thread. Lawrence and Obergefell, while far less hazardous to human life, are as lawless as Roe. Note that he doesn't say that Lawrence and Obergefell aren't hazardous to human life, just that they are less hazardous. So I'd love to have some expansion on what that means. But ultimately, the point here is that privacy hangs in the balance. And so if you care about privacy, then you should care about what's about to happen in Dobbs in just a few months. So in my last bit of time here, I really want to end with a story, and then also by posing some questions to you. Now, many of you certainly know about the case of Buck versus Bell, one of the most notorious cases from the eugenics era in the United States, when many states had laws that allowed for the forced sterilization of people who were considered undesirables. And in this case, Carrie Buck was considered to be a person who was quote unquote feeble-minded and therefore a candidate for forced sterilization. And in that opinion, Justice Holmes famously wrote, 3 generations of imbeciles are enough, right? One of the most infamous quotes, I would say, from a US Supreme Court case. So lots of people know about Carrie Buck and her family, but I want to talk about another family. I want to talk about the Relf family, and particularly the Relf sisters. The Relf sisters were Katie, Mary Alice, and Minnie. They were 3 sisters who were living with their parents in public housing in Montgomery, Alabama, in 1973. And Minnie and Mary Alice were the 2 youngest girls, both of whom were developmentally disabled. Now, this family, like a lot of poor Black families at the time in Alabama, were receiving various kinds of services from the Family Planning Clinic of the Montgomery Community Action Committee, which was funded and controlled by the Office of Economic Opportunity, which was a part of the Department of Health, Education, and Welfare, which was later renamed to the Department of Health and Human Services. So a federal agency was funding this work that was happening. And for many years, representatives from the CAC were deeply involved in the reproductive health care that the Relf sisters were getting, starting with giving experimental birth control shots to Katie in 1971, and then also starting to give those shots to the girls, to the younger girls later on. Bringing Katie to the hospital to get her an IUD in 1973, even though she didn't ask for it and her parents didn't ask for it. And then also in 1973, a nurse showed up one day at the Relf home and picked up Mrs. Relf and Mary Alice and Minnie, who at that time were 14 and 12 respectively. They ended up at a local hospital where the nurse asked Mrs. Relf to sign a consent form. Now, Mrs. Relf couldn't read or write, and she believed that what she was signing was a form that would allow for the continuing use of the birth control shots that the girls were already getting. So she signed an X on that consent form, seemingly to agree to treatment for her children. She was told to leave the girls in the hospital, which she did. They stayed overnight. And the next morning, doctors administered general anesthesia to Minnie and Mary Alice, and surgically sterilized both girls. And I'll remind you again, they were 12 and 14 at the time. And in this picture, you can actually see the scar from that surgery. Now, this kind of abusive use of sterilization against 2 poor Black girls was part of a much larger pattern of forced and coerced sterilizations conducted in this country, often in public hospitals and across the country. Right? So we had the same thing happening in California with Puerto Rican women. We had it happening in the South with Black women. We had it happening in Puerto Rico. And so, Fannie Lou Hamer actually used to refer to these procedures as Mississippi appendectomies because they happen so frequently. A Black woman would go into the hospital for regular care or for obstetrical care, and she would be sterilized oftentimes without even being told that that was happening. Eventually, the Southern Poverty Law Center filed suit on behalf of the Ralph sisters and others who were similarly situated, and the lawsuit ended up settling by creating significant standards for consent for sterilization procedures. Now, I shared the Ralph story in some detail because it's really vital in this reproductive healthcare space to take note of the ways in which reproductive oppression and reproductive hierarchies have very deep intersectional implications. So for the Ralph sisters, it was this combination of being Black, female, developmentally disabled, and poor that led to their unconsented sterilization. So we sit here now at what I would say is a critical point in our country and in our political system, in our democracy and in our courts. The pandemic has really shown a glaring spotlight on issues that aren't at all new, but that continue to plague us because there is insufficient political will to make them relics of our past. The end of Roe is a scary prospect for those of us who are pro-choice, but poor women, women of color, women in rural communities, young women, undocumented immigrants, and others have had limited access to abortion services for years, as states have used the leeway created in Casey to drive clinics out of business and create insurmountable obstacles to those who were seeking abortion care and who had little resources. Our failure to provide affordable, high-quality childcare, an acceptable minimum wage, adequate enforcement of laws against pregnancy discrimination in workplaces dominated by low-wage workers or affordable housing means that choices about pregnancy and parenting are too often made based on the deep inadequacy of our social safety net and the lack of enforcement of our often stated but seldom realized so-called commitment to families and family values. The failure to reform the law on qualified immunity means that police officers can continue to take the lives of our fathers, our sons, our daughters, our mothers, and friends with little or no repercussions. And engaging in the fantasy that race is no longer a dominant axis of oppression in this country means that the court can erase critical parts of the Voting Rights Act and watch as states pass voter ID laws, close polls in communities of color, slash opportunities for early voting and mail-in voting as a modern day version of poll taxes and literacy tests. We know where so many of our societal failures lie, but we refuse to fix them, not because they can't be fixed, but because doing so doesn't serve the interests of those for whom white supremacy, by any name, is better than a country that truly lives its professed ideals. So for me, the most important lesson we can draw from the pandemic is that we continue to march down a very wrong path and that there is much, much work left to be done. The fact that in a relatively short time frame in this country, we watched a pendulum swing from a supposed racial reckoning to the passage of laws banning critical race theory in elementary schools to protect the feelings of white children, that tells me that the lesson has been very lost on so many of us. Now, this is a very bleak assessment for a Friday. I accept that. So I promise I will say something uplifting before I end, but not quite yet. So I want to be clear that I'm not taking the position that the only way to protect these rights that I've been talking about, these rights that so many of us hold dear, is through the right to privacy, and perhaps appeals to equality or even the freedom guaranteed by the 13th Amendment, as some have argued, will ultimately come to our rescue. But I don't hold out hope that this Supreme Court, certainly not as it is presently construed, has any interest in actually protecting these rights or recreating them if Roe gets overruled. But if we have to wait for the court to change for other arguments to find sway, we know exactly who will suffer. The same women who are suffering now because their needs are not centered in our discourse. We're living through extraordinary times that tragically highlight how ordinary oppression is in this country and how deeply and swiftly those with power consolidate their strength when they see their ability to dominate the narrative starting to slip through their fingers. As the amazing scholar Dorothy Roberts has said, quote, The thing about reproduction is that more than anything else, it tells us how a society values people, end quote. So are we going to continue to live in a country where privacy is a privilege for some and a right for others? Will privacy become even more of a luxury good to be doled out along the lines of race and class to those who already sit at the top of our reproductive hierarchies? And a final question, which is really a paraphrase of a question that was posed by Justice Sotomayor to the SG during the Dobbs argument: will this country survive the stench that our failure to change creates in the public perception that the Constitution and its reading are just political acts? So I'm going to end, and I know I'm running out of time, so I promise I'm going to do this quickly. The other day, I have a 14-year-old and a 16-year-old. And the other day, my 16-year-old said to me sort of offhandedly, I'm kind of worried about what the world is going to look like when I'm an adult. And my response, and this will tell you what kind of parent I am, my response to him was, you should be, which he said was not very comforting. But it's true. We are giving a very upsetting world, I think, to our children. Now, I think that we can do better. And in large part, I believe that, one, because I do have a 14-year-old and a 16-year-old, and I have to believe that this world can be a better place, but also because I get to spend my days with law students, with people who all of us are training to go out into the world and to use the skills that we are giving them to actually make this country what it has long said it wanted to be, but has never actually been. These are the folks, my students, my graduates, my young alumni. These are the people who help me get out of bed every morning, keep moving forward, and keep fighting the good fight. So my positive end here is to the students who are listening today. We are counting on you. We believe in you, and we have faith that this country will be better in the future because of the skills and the beliefs that you are bringing to the fore. Thank you.
Thank you, Dean Mutcherson. Hello, everyone. My name is Madison Gerhart, and I am a staff editor for the Kansas Journal of Law and Public Policy. I have the honor of introducing our next speaker. Professor Landers is a professor of law at Suffolk University Law School and is the faculty director of the school's Health and Biomedical Law concentration and the Master of Science in Law Life Sciences program. At Suffolk, she teaches administrative law, constitutional law, health law, and privacy law. She was a distinguished visiting fellow at the National Academy of Social Insurance during her fall 2018 sabbatical leave, and recently helped complete the organization's report examining approaches to expanding Medicare eligibility, key design options, and implications. Currently, she serves as the president of the board of directors of the Academy. In addition to healthcare, Professor Landers has written on privacy and diversity in the legal profession. She is a regular commenter on the legal developments in constitutional law, health law, and administrative law for media organizations. Professor Landers has served on the board of numerous civic and educational institutions and has received numerous awards for her contributions to the community. Currently, she is a trustee of the Massachusetts General Hospital and is a chair of the board of Planned Parenthood League of Massachusetts. She served as chair of the American Bar Association section of Administrative Law and Regulatory Practice in 2016 to 2017. In November 2018, she was elected a fellow of the ABA section of Administrative Law and Regulatory Practice. President of the Boston Bar Association in 2003 to 2004, she was the first woman of color and the first law professor to serve in that position. She has worked in the private practice and served as Deputy General Counsel for the U.S. Department of Health and Human Services, and as Deputy Assistant Attorney General in the Office of Policy Development in the U.S. Department of Justice during the Clinton administration. And with that, welcome Professor Landers.
Thank you so much, Melissa, for that really nice introduction. I also want to thank all of you at the University of Kansas for this opportunity to consider approaches to respecting individual privacy and dignity, as we seem to be taking perhaps some premature steps to emerge from some of the harshest restrictions occasioned by the responses to the pandemic. I want to thank Dean Murchison for her really excellent and comprehensive situation of the concerns and the focus about privacy on by focusing our attention on the broad the broad scope and expanse of the reproductive justice movement in the United States. I think that in many ways, she highlights how important privacy is in actually allowing people to achieve the ambitions and the goals that they have in their lives, but that there are many, many other societal structures that are necessary to support privacy and that are key to allowing them to achieve their goals. So as she noted in that really wonderful keynote address, the concerns about the adequacy of privacy protections in the United States are not new, but as in many other sectors, the pandemic has focused our attention on these considerations in different ways. And one challenge for this symposium, as her talk alluded to, is that privacy transcends many realms. From law students, the first introduction to privacy may be in a torts course, considering the various forms of actions for intrusion upon seclusion, misappropriation of a person's likeness or image, and the revelation or exposure of private facts, and so forth. Another introduction occurs in constitutional law, as Dean Mutcherson really outlined quite effectively, with the consideration of the right to privacy that the Supreme Court has recognized in the substantive due process doctrine, encompassing the right to have access to contraceptives, abortion, the right to form intimate relationships with adults of one's choosing, the right to marry, and the right to control the upbringing and education of one's children. All of these things she covered comprehensively in the keynote address. A privacy course might consider the myriad state and federal statutes that protect privacy of certain types of information, particularly relevant to the conference today, health information, but there are also statutes that protect the privacy, the confidentiality of credit and other financial information and educational records, just to give a few examples. And finally, in the international context, the EU's General Data Protection Regulation appears to be create the possibility for raising the bar for privacy protections or protections of the privacy of some of this information in these different categories. In the area of law enforcement that the keynote also addressed, a criminal procedure course will consider the right to be free from government intrusion under the Fourth Amendment. And then under the First Amendment, we have a right to privacy in our thoughts, our intellectual pursuits, and to pursue, intellectual pursuits of our choosing. Dean Mutcherson also emphasized this when she talked about some of the emerging efforts to place restrictions on the kinds of materials and the kinds of topics that students can consider in schools, in public education. And so some of the dangers posed to privacy that I'll talk about briefly in this talk today are the Texas SB 8 statute that locates enforcement of the statute's a ban on abortions after 6 weeks of pregnancy in the hands of private citizens. Already talked about, I mentioned the bills pending in legislatures and in local school boards to restrict the ability of teachers to assign work and to allow, again, another private enforcement mechanism for parents to report teachers who assign work that parents don't like. And then I will also talk about privacy protections and the need for them, the greater need for them in the context of some of the income support programs in the country, such as unemployment insurance, which was a challenge situation during the pandemic. And then sort of try to connect some of the themes that Dean Mutcherson outlined in her talk. So just as the recent wildfires of the last fall season and severe weather events that continue to occur have provided warnings about the need to address climate change, the COVID-19 pandemic made plain the gaps in the public health, healthcare, and social insurance infrastructure of the United States. During the pandemic, long extant disparities in the social determinants of health and access to health insurance and care became more obvious, impeded efforts to contain the spread of the virus, and slowed acceptance of vaccines when they became available on a really amazingly quick timeline. For example, people whose jobs did not allow for remote work, who needed to take public transportation, who resided in situations that did not allow for social distancing, isolation, or quarantine, people who had a lack of access to privacy were more vulnerable to the virus. People with poor health status were disproportionately at risk and affected. And there was obviously, as the dean's talk indicated, a racial disparity and a racial divergence in those health outcomes. And then historical suspicion of the healthcare delivery system and the prevalence of misinformation about COVID-19 and the vaccines resulted in a hesitancy to accept vaccination for the disease. So because of the persistence of the pandemic and the nature of the patient care process for the disease and the failure of some substantial portion of the public to take the disease seriously, the energy and the morale of the healthcare workforce has become depleted. Like other workers in the post-pandemic economy, some are reevaluating their commitment to the field. And the fragility of the workforce supply exposed the chronic underinvestment in populating a pipeline of trained and diverse healthcare providers across the care disciplines. In late January, and events perhaps are not necessarily improving. In late January, just last month, one of the major academic medical centers in Boston has been the object of demonstrations and protests. The first one was objecting to a requirement that candidates for solid organ transplants must be vaccinated against COVID, as well as many other diseases. And then an unrelated demonstration started that targets the hospital's racial equity work as killing white people. So I will confess that I've never been a First Amendment absolutist. I recognize that that's a controversial statement. And so, for example, in the abortion context, the Supreme Court decided a case in 2014 called Mccullen against Coakley, which involved a buffer zone that had been created around the Planned Parenthood clinic, where I serve as the board chair, as the introduction indicated. And the court struck down the buffer zone against, in the face of a First Amendment challenge. And the buffer zone had been created to allow patients, people accompanying them, healthcare workers, to enter and leave healthcare facilities that provide abortions, among other services, without, being closely harassed and receiving the taunts and protestations of, people who were demonstrating against the provision of abortion services. So I think that this law, the Supreme Court decision will make it, does not really bode well for the ability of the hospital that in Boston to stop the intimidation and harassment of healthcare workers who disagree with some of the hospital's policies that are designed that are rooted in the science about healthcare outcomes in the case of the transplant, the vaccine requirement for transplant recipients, and also that are rooted in trying to address some of the problems of health equity that the dean's keynote address identified. Another concern is that people visit reproductive healthcare clinics for a whole variety of reasons, not just to obtain abortion care. And relying on private citizens to enforce laws, such as the recently enacted Texas law, which the Supreme Court has refused to stay in contravention of much of its historical approach to these sorts of situations, not only expose healthcare providers and patients to intrusive and intermeddling litigations, but will also cause providers and patients to have to reveal other private information in defending against these litigations. So we're creating a society of tattletales, of people inserting themselves into the private affairs of people that they don't even know, which is, a fundamental abuse and intrusion on the privacy of people to receive healthcare. And then at the same time that is going on, those intrusions are going on, vaccine opponents are weaponizing privacy in claiming a right to refuse the vaccine and then a right not to disclose their status so that they are, their argument is that they are entitled because of their freedoms to continue to go about society and expose others to, actually quite significant healthcare risk because of the communicable nature of the COVID virus. So this is, a very, series of threats. As I think some of the later speakers will address more directly, telehealth has always presented privacy and security concerns, as well as there are, the issues that I'm sure that they'll deal with about, the way the state-based professional licensure regimes really do create some barriers to full adoption of telehealth. But in the pandemic, one of the bright lights was that the policymakers saw the need to place greater reliance on remote healthcare delivery. But those decisions that released some of the regulations that prohibited the robust use of telehealth. Some of them have been temporary, have been rescinded. Some of the payment options available for telehealth services are now, it's uncertain whether they will continue. But in the reproductive healthcare space, telehealth has the potential to enhance access to medical abortion and other reproductive healthcare services, and therefore sidestep some of these intrusions that that Texas law SB 8 and the inability to prohibit harassment in public near reproductive healthcare clinics. So telehealth presents the potential to avoid some of those problems that prohibit access to care. So now I'm going to shift a little bit to talking about really what is my one of my main themes, which is that as my introduction indicated, I do a lot of work with an organization called the National Academy of Social Insurance. And you might ask, what is social insurance? So social insurance are programs in which there is a comprehensive work-based investment in programs like unemployment compensation, workers' compensation, health insurance, retirement, like the Social Security system, the Social Security disability system. And increasingly, the concept is encompassing public investments in family leave and caregiving infrastructures. And as we saw, and as the dean's talk indicated, the lack of, some of these structural supports for families and the economic security of the population generally, revealed, major weaknesses in our social structures. And so the happy news is that federal financial measures provided some temporary relief, but the risk of future insecurity remains absent a creation of more permanent structures for providing for the economic and social well-being of all. And so, I maintain that one of the big barriers to really achieving equity and full consideration of privacy or full realization of people's rights to privacy does rely, or one of the barriers is the inadequacy of the economic resources and economic security that people experience. And that unless the nation does something to address that economic insecurity, all of these problems of inadequate privacy, inadequate ability to, pursue health and healthcare will continue to be with us. I want to give one example about how the pandemic has actually highlighted some of the weaknesses of these programs. So the operation of the unemployment insurance system is basically a state-based function, and the federal government in times of crisis like the pandemic or like the 2008 financial crisis, the federal government often steps up to augment state resources. But the tax is local tax on employers. People are not eligible for unemployment insurance unless they've worked for an employer who has contributed to the system. And similar, people are not eligible for Social Security unless they've made contributions throughout their working lives or for at least some period of their working lives. And so because many people, worked in the gig economy, and who were self-employed, those workers in those categories were not eligible for unemployment insurance. And then in addition, there had been underinvestment in some of the computer systems and administration of these unemployment insurance systems, and so the systems were overwhelmed and became the targets of massive organized fraud and identity theft. People have filed 2 different sets of false claims, unemployment compensation claims in my name, in my home state, and in another state where I have never lived. So the need to address the privacy and security of these kinds of programs that are absolutely crucial for people who need them at the time of crisis is absolutely something that needs to be on the agenda for the future. And then, we could have a very large conversation about how the protections for privacy and security of information, private information generally in the United States have been long thought to be inadequate. And because of the sectorized basis for privacy protections, depending on what kind of information it is. And but the protections for privacy and security of information, in state unemployment agencies and in health and healthcare is going to be a really important task going forward. One example of one of the gaps in the protection for this information is that, as you probably, many of you know, the HIPAA privacy regime only applies to certain covered entities, healthcare providers, health insurers, healthcare plans, and to healthcare clearinghouses. And so a lot of organizations that use and collect health information, mobile devices, that you might use to monitor your exercise, your diet, all those sorts of things may not be protected from disclosure and may be used by these companies. And so I was reading this week that recently the insurance industry has now called on Congress to actually kind of level the playing field for all of this kind of health information. And so, all of that needs to be a response to protecting privacy now that the public has a greater understanding of how exposed all this information is, how vulnerable the systems are to fraud and identity theft, and how the inability of people to have the resources to make arrangements for private living, private spaces in their living, and to be free from government surveillance really does impinge on our rights. And I finally, in the educational frame, we've already talked about, this effort to restrict what people can learn about the history of the country, to protect students from information that might cause them, distress, or to reconsider some of the arrangements in the country. Another educational task in front of us is a campaign to really improve the health and scientific literacy of the public at large, and to so that there's a greater understanding of when public health interventions are taken, about perhaps why they are necessary, and how it has to be a collaborative effort on the part of, and a communitarian effort on the part of all of us. I think that, in the discussion, I look forward to the discussion, but I see as key to eliminating some of these inequities and addressing concerns about privacy, that the key feature is enhancing economic security, which will enhance access to health insurance and healthcare, and also, if we, and at the same time, we need to expand the protections for privacy as we expand the capacity to deliver healthcare through technology. That those are really, really important efforts to protect the privacy of individuals in ordinary times and also in times of crisis. So thanks very much.
Thank you, Professor Landers. My name is Stephen Tujak, and I am a staff editor for the Journal. I will now introduce our next speaker, Professor Leah Fowler. Professor Fowler is a research assistant professor at the University of Houston Law Center, where she is research director in the Health, Law, and Policy Institute. She is also a health policy scholar at Baylor College of Medicine's Center for Medical Ethics and Health Policy. Her research focuses on the ethical, legal, and social implications of healthcare innovations, with special interest in consumer health technologies, digital health surveillance, and smartphone applications. Professor Fowler has a background in law and public health and conducts interdisciplinary collaborative research that has appeared in both legal and peer-reviewed journals. Her scholarship is published or forthcoming in publications such as the Notre Dame Law Review, Northeastern Law Review, the American Journal of Law and Medicine, the Journal of Legal Medicine, Pediatrics, the Journal of Adolescent Health, Health Promotion Practice, and the American Journal of Bioethics. Welcome, Professor Fowler.
All right, let's get this screen shared. All right. that should have us good. All right, thank you so much for the kind introduction and to the hosts of the symposium for organizing such an interesting and important event. And thank you to all of the wonderful speakers for presenting such exciting and also terrifying ideas. I think it's fascinating to see how everyone has interpreted the prompt and imagined a post-pandemic future, either from listening to the presentations and reading titles and imagining what they might be about. And all I can say is I can't wait for the papers. So when I first saw the symposium's prompt about how the pandemic might reshape the healthcare system and how we approach telehealth, technology, and social disparities, my first thoughts were regrettably cynical. For me, and I would venture to say for many of us here, the general sentiment is that the US's pandemic response has fallen woefully short of good. And so it's a bit difficult for me to imagine any kind of positive transformation in its aftermath, especially after 2 years of what feels like nothing but a fire hose of bad news. But counter to all of the things that I felt inside of me, I wanted to push back against my first very negative instincts and take a different approach to the prompt than maybe I had originally thought. So instead of dwelling on things that didn't and continue not to go particularly well, I wanted to think a little bit more aspirationally. I wanted to use this as an opportunity to dream a little bit bigger. And that is probably because I've deeply depressed from the pandemic and I just am so tired of bad. And that's how I came up with what is admittedly a very simple premise. I thought, what if we looked around at all of the ways people misunderstood the protections that we afford health information during the pandemic? And instead of just writing a bunch of fact-checking articles or making fun of them on Twitter, we could use it to inform targeted public education about privacy confusion. Because the position I take in my paper is that we are at a critical point for data privacy in this country. And if we want to envision a future for privacy protections, maybe dreaming big is the way to go. Maybe we can look at something bad and imagine something good. And after the concluding thoughts from the keynote, I'm pleased to know that this is a shared, if not fragile, sentiment. So with that background, I'm going to use my presentation as an opportunity to briefly explain the ideas I write about in my paper. I will be discussing some examples of how HIPAA emerged in objections to pandemic responses. I will then talk about why existing protections don't generally apply in the ways people assume, and some of my theories about why that confusion may persist despite all of our very comprehensive fact-checking articles. And finally, I'll talk about why I think the state of affairs of privacy understanding is particularly concerning right now at this point in history, and maybe gesture vaguely at some opportunities to address it. So without further ado, let's talk a little bit about where we've seen some of this confusion about health data privacy over the last 2 excruciatingly long years of the pandemic, keeping in mind that this is not an exhaustive list and it is not the only type of objection that was raised. So for purposes of my paper, I consider health data privacy objections to 3 different pandemic control measures. Those are masks, vaccination cards and status questions, and contact tracing. Now, I think some of these are probably more intuitive than others, so it's worth spending a moment just explaining them. Though again, do want to underscore that these were not the only types of objections we saw. So with masks, there was an interesting argument circulating that if you asked somebody why they were wearing a mask, it would require them to divulge information about themselves and would therefore violate some kind of perceived HIPAA right. And you can see an example of this in a tweet from a bowling alley that it's expressing their policies on masks. Now with vaccines, both cards and status more generally, we saw very similar objections that to answer the question would require disclosing something that the disclosee thought was protected. But what was different about vaccines was that we also sometimes saw these incorrect statements about HIPAA from extremely high profile people with very, very large audiences. And that includes politicians like Marjorie Taylor Greene, as well as some professional athletes like the football player depicted here. And finally, there were concerns about contact tracing violating HIPAA, especially concerning sharing information about who'd been exposed and where and their infection status. And this ultimately translated into distrust and difficulty convincing people to download apps or answer contact tracer phone calls. And while I am sure there are a lot more examples, what I hope this begins to illustrate is the general sense that people have that health information is special, and that because it's special, it gets special treatment no matter where it is. And on some level, I think these assumptions make some amount of intuitive sense. I think everyone has some experience with the health system or signing a HIPAA authorization form. They know that certain information in their health records gets certain protections. So the logic would then go, why wouldn't that exact same information get protections elsewhere? And what everyone here knows is that HIPAA doesn't just attach to health information because it's health information. It attaches to certain types of health information in the hands of certain types of actors, namely buzzwords like covered entities and their business associates that we've already heard today. And it's also subject to all kinds of nuance and exceptions. But given that the audience here today likely has a lot of familiarity with health data privacy, this talk doesn't actually just have to be a talk about HIPAA. All I want to do here is highlight that there is significant confusion about what HIPAA is and does for the public, which, among other things, has prompted a series of articles trying to fact check claims after they've already entered the public discourse. And you can see some of those headlines here. And while HIPAA is absolutely not the only force in health data protection, it just happens to be the one that's most familiar to people. And importantly, if an old and well-known name like HIPAA still manages to generate so much confusion, it doesn't bode well for any of the newer or more obscure privacy laws coming down the pipeline, especially the ones that are a lot more difficult to understand. So I hope I have convinced you, both in this presentation and ultimately in the paper that I know all of you will read with great interest, that we as a country suffer from a bad case of HIPAA confusion. And while I think we have probably known that for a long time, the pandemic has managed to shine an enormous spotlight on it at a population level. But like I said in my introduction, I want to think more aspirationally about the state of affairs. So my paper takes the position that it doesn't have to be this way. So just to recap, at this point in my paper, I have established that pervasive privacy-based confusion, and I do that through 3 public health interventions and talk about why HIPAA doesn't apply to those examples in the way people seem to think it did. And in the third part of my paper, which is sort of the concerns and opportunities sections, I turn to what we're currently doing, what we could potentially do instead, and why I think it matters now more than ever. So the first thing I do is I acknowledge that we're not doing nothing, if you'll allow me a double negative. In my earlier slide with all of the headlines, we see a ton of experts commenting in articles, trying to debunk myths, and that includes a lot of our esteemed health law colleagues, many of whom have been all over the news over the last 2 years, doing really amazing work to educate the public. Second, we've seen growth in what I'm just going to generally refer to as informal shaming approaches, which include things like Twitter accounts like Bad HIPAA Takes, which basically just curates and mocks HIPAA tweets and calls out common misspellings. And I include Bad HIPAA Takes kind of begrudgingly because 1, I don't actually know if it's doing any sort of meaningful work by making fun of people. And 2, I think there's a growing understanding in the public health literature that shame is just not a very good tool for doing much of anything, despite how much we seem to employ it. And while these are certainly something, and something is indeed better than nothing, one of the things I observe is that a key problem with these approaches is that they are reactive. That we're always trying to catch up to a problem that has become too big to ignore instead of just trying to address the root causes. And my paper suggests that maybe we can do better than that. Maybe we can look at the pandemic and see clear examples of how and why people misunderstand HIPAA. We can acknowledge that people seem to think that health information is special, and that because it's special, it already has special protections no matter where it appears. And I then suggest maybe we can look at historical examples of public education campaigns that have accompanied policy efforts. For example, like those used with tobacco. And we can do something better for privacy on a population level to try and change this public misperception and incorrect sentiment. Because I'm of the opinion that it's not actually the public's fault that they don't understand privacy. They've been showing us that they don't understand privacy for a really long time, and we've fundamentally changed nothing about what we're doing. And I think privacy, especially digital privacy is extremely confusing, which is something I say as a person who has the luxury of sitting around and thinking about digital privacy probably more than the average American. Now, I think it is a particularly critical time for these types of efforts, and here's why. I speculate in my paper without any real evidence, but it's my paper, so I get to do those kinds of things, that a contributing factor to more people not pushing harder for better data privacy protections is that they mistakenly believe that they already have them. Now, I do note that this is an empirical question, and if we wanted to, we could find out if this is a valid theory and kind of the scope of the problem. I also speculate that new laws and regulations, including the latest push to expand the health breach notification rule, may mean little if we don't also pair it with real dedicated efforts to help people understand what rights they do and don't have with respect to their sensitive information. Because I think most people on the street are not going to be in the know about the health breach notification rule. And even if they were, it's kind of hard to get at the details of. Even I'm still trying to wrap my head around it. Because I offer that if we want to see movement on building a culture that values privacy before everything in our life is on a smartphone or part of the Internet of Things that's actively surveilling us at every moment of our lives, we have to start sooner rather than later. And because it's my paper and I can dream as big as I want, I also offer that if we want people to buy into beneficial data uses, we have to help them understand why it's important and the limitations of those uses, which is to say how they'll be protected. And in that way, they might learn to embrace some kinds of socially beneficial uses of data sharing and not just fear it, which was something that we saw a lot throughout the pandemic. And of course, this touches on an important point that Professor Landers also made about enhancing health literacy in the United States. Now, I will be the first to admit that the who and how and critically, who is going to pay for this questions linger unanswered in the background of my paper. And I acknowledge that those are very good and important questions, but I don't actually have any answers to them right now. But I figure if we start putting out the idea that we could do something different with privacy literacy in the United States, we'll eventually be able to flesh out the details. So thank you so much for listening to me dream big aspirational dreams today, instead of just being a pandemic and privacy grouch, which was what I initially wanted to do. Even if those dreams were maybe a little bit light on the details in some places. It was a pleasure to join you, and I look forward to the rest of the symposium.
Well, thank you, Professor Fowler. My name is Kyler Womack, and I'm also a staff editor for the journal. I will now introduce our final speaker for panel 1, Professor Barry Furrow. Professor Furrow is a pioneer in the field of health law. He is the lead author of Health Law, Cases, Materials, and Problems, now in its 8th edition, which remains the leading casebook in the field. He's an influential scholar, named number 10 on the 20 most cited health law faculty list, published by Harvard Law School's Petrie-Flom Center in 2018. His expertise spans health-related topics such as healthcare regulation and finance, patient safety, patient privacy, mental health, bioethics, and legal issues of death and dying. He has authored or co-authored more than 9 health law books and has written dozens of law review articles on health law topics in journals such as the University of Pennsylvania Law Review, Duke Law Review, Harvard Civil Rights, Civil Liberties Law Review, and the Drexel Law Review. In 2018, he was selected by the U.S. Department of State Bureau of Educational and Cultural Affairs to serve as a Fulbright specialist. In that capacity, he continues to consult with faculty and students at academic institutions in Italy and elsewhere. Professor Furrow earned his JD at Harvard Law School before clerking with the Superior Court of Massachusetts and handling civil litigation and health law cases with the Boston firm Palmer & Dodge. He is an editorial board member and former editor-in-chief of Law, Medicine, and Healthcare. He serves as a peer reviewer for the Milbank Fund Quarterly, the Journal of the American Medical Association, Health Affairs, the Journal of Legal Medicine, and the Yale Journal of Health Policy, Law, and Ethics. Welcome, Professor Furrow.
Am I here? There we go. Hello, everybody. It's been a wonderful conference so far and extremely interesting. I want to thank the University of Kansas School of Law and the Law Review for having this conference and allowing me to participate in it. Let me frame what I'm trying to do today. I'm not going to talk about privacy. I want to talk about dignity as it's phrased in the Law Review's call for papers. I think that dignity requires equal access to healthcare. And I want to look at telehealth, which strikes me as one tool to improve access for large vulnerable groups in our society and reduce their insecurity. So let me share screen and pull up my slides. Okay. All right, so typically for me, I have a lot of slides and I will go through them rapidly, focusing on ones that make the bigger points and leaving others for examination after the fact. Of course, my paper will take up in more detail some of this. So I'm excited about the expansion of telehealth. It seems to me to have a lot of potential. One of the few positive aspects of the pandemic is that people have come to rely on virtual visits with doctors. And we've gone from 10% using telemedicine to 70% at this point, a pretty high acceptance rate. The positive side of it and the complicated side of it is that vendors are proliferating. They see an opportunity to make money. There are a tremendous number of startups with investor money flowing in. It's, in a sense, today's gold rush. And they're excited to uproot and disrupt current health arrangements, which I think may turn out to be a troublesome problem. So we've had rapid adoption, as I indicated, and we have relatively high patient satisfaction with regard to telehealth as being acceptable alternatives, or even better than the alternative of live doctor visits. And the experts predict lots of areas of rapid expansion of telehealth, things that we need to have: chronic care management, mental behavioral health, urgent care, and so on. So it sounds bright and exciting. And I always start my research by looking at what the vendors say, because that's often pie in the sky, but you need to get a frame for what people see as important. And remote health services are defined, as you can see in this slide on the left side, by these overlapping Venn diagrams of telehealth and telemedicine. I'm going to use telemedicine exclusively because I think it includes a broader range of things, including non-live as well as live encounters. So I define it as asynchronous, patient-centric telehealth, portals, virtual appointments, remote monitoring, and personal health records that are easily accessible to a doctor with or without the patient being handy. And more importantly, live clinical encounter platforms. And here you can see one vendor's very attractive marketing for a secure and encrypted cloud-based telemedicine platform. So they promise encryption, HIPAA compliance, everything you want. And remote patient monitoring straddles the telemedicine, telehealth kind of definitional problem, because you can have data flowing in all the time to a remote monitoring server, and you can have a live connection. And most excitingly, everybody's jumped into the game. You can have the provision of learned second opinions by physician rock stars. This is the Cleveland Clinic creating the clinic. 3,500 expert specialists, the best you can get. I don't know how much this is going to cost. So who are the underserved populations I referred to who really don't have good access to healthcare? Well, this is a recent Health Affairs article that looks at underserved by proximity to care. And you see it here. The dark brown means you're more than 30 miles away from anything resembling a provider. There's a lot of this focused in North Dakota, South Dakota. You see it, some of it in Montana, Idaho, Washington State, and Oregon, and so on. So we know there's a problem. Okay, I have to back out of that. And we know that people are underserved by both economics and social determinants. So we have the digital divide. Full digital access, almost 45% of the population, 15% without a desktop, 14% without a smartphone, no digital access, 26%. Hopefully this has improved since this data was produced. So I want to treat 6 different special cases, and I'll try to do it efficiently in the time I have. Rural life, number 1, and the previous US map indicated the gaps in rural America for lots of reasons. Sorry, oops. 15% of all Americans live in rural areas. Rural hospitals are closing at a brisk rate. I think maybe 180 have closed in the last few years, and that's going to continue. And this is a big concern because these populations, it's very difficult to get access. Now, I grew up in southeastern South Dakota as a redneck without indoor plumbing, no dentists and no doctors anywhere within easy driving. And so my dentist tells me that I show the effects of growing up in a rural area. And I have no doubt that's true. So it concerns me, and I do keep up with this because I have a lot of family still in South Dakota. Here are the hospital closures. We're at 138 and 143 from 2005 to 2010. They're scattered heavily in the South. There never were too many in large parts of the West. There are some small family hospitals, family-owned hospitals, there aren't too many. And one of the problems with rural hospitals is that they live on very fragile financial margins, and Medicaid expansion has been a big help to some of them. But of course, a lot of states, the Republican states, did not expand Medicaid, and these hospitals continued to lose money, thus the increasing rate of closures. We also know that Medicaid expansion would help a wide range of minorities who are vulnerable because they don't have access to healthcare. Racial disparities really matter when it comes to access to healthcare. And this is a very typical graphic depiction of that problem. And what happens if you don't get healthcare? Well, here's as simple a graph as you can get. The divide between rural and urban is really quite dramatic in terms of mortality rates, age-adjusted all-cause mortality per 100,000. The rural has stabilized by 2009 and is now it's level and is starting to go up again. That's not surprising. And it's quite a significant gap. So what would it feel like to live in a rural area and have access to remote doctoring? Talking heads on an iPad. These are actually robotic machines from InTouch. It's iRobot, where you have a live conversation with your doctor. They're all very smiley. Or more likely and more promising, I think, is the use of your iPhone to have a live conversation with the doctor. And so this allows for consults. It allows for the possibility of a diagnostic conversation and referral to a stroke specialist, maybe even one of the Cleveland Clinic rock stars. And one of the problems, of course, to this, not quite a fantasy, a promising development, I think, is the limits of broadband. And so one of the things the Infrastructure Investment and Jobs Act has done is to promise $65 billion for broadband expansion, which goes through the states. And you need a state broadband office, and you have to work with utility companies to distribute the broadband. So it's very promising. And there are already very adaptable providers who have done very well with very limited resources. This is the Lumi Tribal Health Center in Bellingham, Washington, one of other examples where the Native American tribes are actually, they're masters at doing workarounds to try to get at healthcare, because healthcare on the reservation is notoriously bad. And in this case, they have turned their behavioral health program into 100% telehealth, and they've expanded through to psychiatry, physical therapy, and dentistry, among others. It's just an example, I think, when you think about telehealth as this kind of a techie sci-fi thing, that it's a tool, and money will help, but there are already groups doing very well in expanding it. And another new element that's worth thinking about is the new concept of rural emergency hospitals, REHs, to provide 24-hour emergency care. Hospitals that have, I think it's 60 beds or less, can convert to these REHs, and it allows them to gain resources and to survive. And one of the recommendations of these REHs, which are just approved, is that the secretary allow for a doctor of medicine or osteopathy to be on call remotely as well as in person. So telehealth was hardwired into the idea of these rural emergency hospitals. I presume Kansas will be seeing some of these, and I would expect South Dakota would. Case number 2, special cases number 2, disabled patients. Very simple to describe the problem. If you're deaf, hard of hearing, deaf, blind, you have low vision, you're speech disabled, you need assistive technology. This is a problem for which patient portals have to be adapted. And this is going to be a slow development, I think, as vendors try to hit people who are largely fully abled. And moving into the disabled environment is more complicated for them. But it's a significant and very limited population in terms of access. Special cases number 3, the homeless. The homeless have cell phones. They have access to mobile technology. They rely on it. They need to know a lot of things all the time. And they keep up very much with the technology. I say this because one of my children, my son, runs a nonprofit called The Way Home in Eugene, Oregon, trying to help the homeless get food and healthcare. And a recent study in 2001 in Telemedicine Health found that telehealth is a healthcare delivery method for the homeless that is accepted by them and definitely increases their access to healthcare, and they're very comfortable with it. More comfortable than they are seeing a doctor in the ER, where it's long waits and often unpleasant attitudes. Special cases number 4, and we've had references to this by other speakers. It's also something that interests me as a core problem that we should be ashamed of as a culture. We have a very high maternal death rate in the US. We have an embarrassingly high death rate. And you can see it on another slide here. Yeah, American exceptionalism shows up very often in very poor health metrics. And here's another example. We have the highest among developed countries. We need more midwives. We need more OBGYNs. And telehealth has a role to play here. Here's a model. You can see lactation support, virtual prenatal visits, at-home monitoring, and so on. It's the perfect environment to extend and reach out to women who are pregnant and step up the monitoring and the advising and the help. And following up on that, special cases number 5, teleabortion. Here's a recent study of telemedicine abortion services, finding that it's safe, effective, and acceptable, and supports the claim that there's no reason not to dispense the abortion-inducing drugs. And you don't need to go to a facility, nor do you need a physician. You monitor by telemedicine. So continuing in the reproductive rights area, special cases number 6, infant mortality rates. Again, we're exceptional for how badly we perform. We're very much, I think only Slovakia beats us. And our infant mortality rates are extremely high. And race, Native American status, all of it, it's all markers for unnecessarily high infant mortality rates. And there's good news here. So part of my focus in telehealth is that there are really interesting pockets of good news. State initiatives very often, provider initiatives, tribal initiatives that are improving access to healthcare by the vulnerable population group. Here's a recent study looking at perinatal regionalization combined with telehealth to improve healthcare in a state like Arkansas. And the intervention has led to lower mortality rates. With a blip here, I'm not sure why, but overall, it's fairly promising data. All right, special case number 6, mental illness. This particular graphic points out Native Americans and Alaska Natives as having very high levels. But I see my 20 minutes are up, so I'm going to speed ahead just a bit, just to flash through some of the slides to make the end point, the importance of telemedicine. The legal dimensions I can develop in my law review article. And it's not surprising, licensure, HIPAA compliance, fraud and abuse, teleprescribing, telemedicine coverage. There's a lot of state law restrictions, and there'll be federal law rules that have to be complied with. Again, I highlight the Interstate Medical Licensure Compact. More and more states have signed on to it. We're up to 34 or 36 altogether with DC and Guam. This is easing the licensing process. HIPAA relaxed its enforcement discretion during COVID. Whether they continue it remains to be seen, as the previous speaker mentioned. Medical liability, completely uncertain at this point. And we'll see how that develops, because there is variation in standards of care. And there are constraints, money, workforce limits, lack of internet speed. Is it going to drive up costs? Is CMS and our Medicare, is Medicare going to be concerned about the increase in take-up? So there are a lot of steps, and I'm going to shoot past this and suggest some negatives, some things to worry about. Watch out for over-enthusiastic innovators and vendors. There's a lot of promise out there, and there are going to be a lot of casualties with these startups, and a lot of money wasted on medical device junk, because there's a lot to sort out before telehealth works, and getting 5G to work in rural areas where it doesn't work very well. And telehealth fraudsters. There's a huge fraud and abuse problem, and the fraudsters are already moving into this domain. And finally, I'd like to end with Amazon Care. The vendors are very excited about this. The healthcare consultants are very excited. My response is, do we have data privacy worries here? Shall we trust Jeff Bezos? I doubt it. Thank you.
Thank you, Professor Furrow. At this time, I would like to invite all of our panel one speakers to turn on your videos and microphones and participate in our panel one discussion. I would also like to invite our audience to submit your questions at the bottom right-hand corner of your screen. You will see the Q&A box, so please submit your questions there. I will go ahead and direct my first two questions to Professor Furrow. First, how do you view privacy as a means of dignity in telehealth?
Well, I think probably the first answer is that dignity has to subsume privacy in your personal information. Dignity is a very broad and hard to define topic, but we don't want our personal attributes and information out there broadly. And the follow-up to the question of how it fits is, of course, we'd like to avoid being robbed, having our personal information stolen, being blackmailed, having demands for ransom, or just tricked. I mean, it seems to me one of the things privacy does is to try to put up a firewall so that we don't get robbed and damaged in any way possible. And what else is dignity except being free of these kinds of incursions?
So I would also say it's an ability to control all of the, the access to this information, that the autonomy with the person to control who has access and how the information is used, that's also an element of dignity.
One thing I would add, just to piggyback on this, is it also touches on concepts of informed consent, especially when we think about data privacy and ownership in the context of consumer health technologies. So much of it is in terms of service and privacy policies that nobody's reading. And what does it mean when we have this fuzzy area between health information that is actually in the context of healthcare and get certain protections and stuff that's outside of it but feels like healthcare? How do we think about ideas of informed consent, and how can people give more truly informed consent?
So there's a recent, sort of people have recently flagged this problem that because of the GDPR, all these websites, when you go on the website now, they ask you to accept the cookies, decline the cookies, whatever. But that whole process itself has given this kind of false sense of being able to control what happens, because people actually, this is to Leah's point, that they don't, they don't read and understand the policies. They don't understand what they may or may not be consenting to. And so that there's now, of course, a movement to try to sort of sort that all out and make that process itself more transparent, which was ironically an attempt to make it more transparent.
And right, what's a cookie, right? You can
exactly.
Something and you're like, that sounds like a delicious choice. Of course I accept cookies.
Yeah, and I think one of the hot areas for expansion is behavioral health and telemedicine, telepsychiatry. And there, I think the confidentiality expectations in a psychiatric relationship are so easily pierced by hackers. I mean, it seems to me once you're in the electronic stream, you have to worry much more about cybersecurity and HIPAA secure processes. So we'll see how that goes, because it's a lot easier in the doctor's office when it's just you and the shrink, or you and group therapy, to say, well, this is pretty secure, but I have no confidence when I'm on my iPhone as to what's secure. So there are just a lot of technical problems that come in under the rubric of protection of personal data, intimate data.
Absolutely. I don't know if there's a question in the chat about the dean's keynote address, and I don't want to speak for the dean, but it's a question about reporting data on, health status issues for the Native American and other indigenous populations. And I just wanted to say that I think that data collection is really a key feature of trying to solve some of our problems, and that a lot of them, one of the, among the many reasons why these problems remain with us is that we don't collect the data and we don't understand a lot about what the problems are. And I do think that trying to be as inclusive as possible in collecting the data should be one of our goals. And I will take it actually as an admonition to me when I give future presentations, about infant mortality rates, maternal mortality rates, and things like that, to really try to make sure that all the groups, racial groups and other groups, are represented. So I think that's a very helpful comment.
Mm-hmm.
Okay, and I'm going to also direct my next question to Professor Furrow. Are you optimistic that telehealth will expand to better serve the underserved people of the US population?
Yes, tentatively. I mean, I think as I went through all the vendors and all the possibilities and the willingness of people to do this, a lot of even the homeless, for example, and some of the tribes are very happy with audio only, for example. So telehealth doesn't have to be these high-tech platforms that vendors are going to charge an arm and a leg for. As long as you can secure the communication, it can be as simple as audio. Remember the fun of talking on the telephone before you had a computer? Well, the intimacy of learning someone's voice, the nuances you can put into it. I think there's a whole richness. It goes back to my memory of the first telephones in the 1950s. South Dakota was about a decade behind everyone else. And it was a primitive on the wall phone. And you really learn people's voices, and intimacy the voice is a wonderful tool, as actors know. Visual adds a lot, of course. So I'm optimistic. I think everybody's going to be jumping into this. And I suggest there'll be a lot of startup casualties. And I worry more about the Amazons, the Walmarts, the big companies squeezing out a lot of the promising startups, and also having negative effects on physician reimbursement and other such things. I don't trust Amazon as far as I can throw it, although I probably have a box coming today, who knows? So it's a problem of complicity with the dark side of some of the larger likely vendors. So am I optimistic? Yes and no. We have to see how this plays out.
I'm sorry, go ahead.
No, I saw a bumper sticker when I was driving into my law school the other day, which was very just plain purple with white letters that said "Back off, Bezos." So I just thought, I'd never seen it before. I just thought that was very funny, because I share your concerns about the Amazons and Walmarts of the world. My optometrist retired in December. December a year ago. Time has passed, and his practice was purchased by my eye doctor. And actually, I've tried going online to schedule an appointment. I thought I'd move my appointments to location near my house. And what they want you to do is, go on to some national platform to make the appointment. I tried calling the local telephone number, and it won't let you do that. And so this is not a good development. It's not bringing the care closer to the patient. So I want to just reinforce that concern you have about these big companies sort of taking over all the space.
And I see that we have two questions in our Q&A box. So I will go ahead and read the first question and pose this question to all of our panelists. All of the speakers today have identified problems in our laws and policies related to privacy, health, and personal autonomy, especially for people from marginalized communities. The pandemic has exacerbated and highlighted these problems in various ways. Is that potentially a silver lining in the sense that the more visible these problems are, the more likely they are to be addressed? Or do you despair that our political processes can or will respond?
I don't want to be a Pollyanna here, but I do actually think that for people like legal commentators on the situation, that when I comment on things like, what is the Supreme Court likely to do in the Dobbs case and things like that, I try to include in my comments reasons for a decision to go the way I want it to go. Because I fear that if the voices are all doom and gloom, they seem inclined to overturn Roe and all of this stuff without emphasizing the ways in which they could get to a decision that preserves access to abortion services. It's just taking one example. That we've given them permission to go and do the bad thing. And so I think, so that's what I try to do. And I, recently published an op-ed because in the Dobbs oral arguments, one aspect of them was this whole discussion about all these wonderful cases that we all admire where the Supreme Court has overturned precedent. And there was a very misleading use of those cases. For example, Brown versus Board of Education. Well, Brown versus Board of Education does not really support Mississippi's arguments because Brown was about setting a federal baseline and prohibiting the states from allowing discrimination. It was not a return of authority to the states, which is what they're asking for in the Dobbs case. And then there was another case, they referred to the Miranda decision overruling prior precedents about, no exclusionary rule and that it didn't apply to the states. That too was misleading because again, it was setting a federal baseline to protect individual rights. And second, in I think it was 2000, it's around 2000, the Supreme Court had another case where they explicitly were invited to overrule the Miranda decision. And Chief Justice Rehnquist in that case wrote the court's opinion that was 8-1, where he said, even though some of us might have decided Miranda differently when it was decided, it has become part of the popular culture, the culture of the country, and we therefore need to uphold it. So this whole, it's all very misleading, this discussion about what the role of the court is in overturning precedents or upholding them. And I think that, I think we need to get those kinds of reasons out into the discussion. So even if it doesn't persuade the court, it actually, people understand how the court is manipulating things in a way that is not supportive of individual rights. Sorry, that was my soapbox on that point.
So let me respond and try to fly down closer to the surface in terms of what I see as beneficial. So as I said, I was born in South Dakota. What do I think of South Dakota now? Evangelical right-wingers and a governor who's a Trumpist. But if you look at the World Health Associations and their studies and their position papers, they're out there trying to improve access. They aren't interested in the political warfare. They're trying to help rural people who are often poor and have lousy incomes and don't have easy access. They're trying to help them. And so the rural emergency hospitals are undoubtedly going to be at the state level very important, regardless of the political leanings of the state. At the level of people who function and trying to reach out, they're not bad people. You forget in our politicized culture that there are a lot of good people that are just trying to do their job and try to extend healthcare or whatever their goal is, constructively. So if that's Pollyannish, maybe a little bit, but I've been reading a lot of these state level documents and looking at state studies. You know, in Arkansas, there's a lot going on with reproductive health, you know, and it has nothing to do with politics. It has to do with academic medical centers and doctors and trying to pull things together to improve all these metrics that are so terrible. So I guess that makes me modestly optimistic.
Well, I'll be a bit of the panel Pollyanna, but I do despair constantly, all the time, about many things. But as somebody who writes at the intersection of consumer technology and health, I actually have a little bit of optimism, even though sort of the opposing forces, being big tech, are large and well-resourced, that we have a current administration that's acutely interested in reining in the powers of big tech. So at least within this tiny subset of the dialogue about privacy, I do think that there is intense political interest and will in helping increase consumer privacy protections. It would just be very helpful if the public recognized the significant gaps and could help push that along.
I do, but the short answer to the question, I think, is yes. I think it does help when the problems become more evident to a broad range of the population and the public, because then I think the political actors will feel like they have the public support, to take these actions, like reining in big tech and all of that. So I think the short answer is yes.
Professor Fowler, I'm going to pose this next question to you from the audience member. This comes from a healthcare provider in Texas. And she asks, as a healthcare provider in Texas, the current progressively disparaging political legal atmosphere seems daunting. What avenues are there available to impact change for individuals outside the legal profession?
Hello, fellow Texan. I know that feeling acutely. It is definitely an interesting time to be here. One thing that I would say is you're in a very unique position in being a healthcare provider, in that when people come with questions, or when we think about how we give somebody informed consent about what we do with their information, it's an opportunity to really check in with them and see if that's something that they understand. And this is a big ask of somebody who genuinely doesn't have a lot of time with any individual patient and likely can't bill for the conversation that could potentially ensue. But to the extent that you know information about privacy, especially health data privacy, you can begin those conversations with your patients, and those types of information sharing and education can begin in that room.
And Professor Fowler, I'm also going to direct my next question to you. Is there a chance that the confusion about health data privacy you identified in your paper is actually just a cover for other political objections? And if so, do you think your argument still makes sense?
So that is a great question and a great point, and one that I definitely try to address in my paper. And I absolutely believe that there's a subset of people invoking HIPAA as an objection that are using it just as a cover for other political objections, or is to do some political posturing, especially when we see it coming from politicians who should presumably know better and have likely been informed after the few times that they've done it. Not that I'm talking about anyone in particular, but I think that in a way, even if it is politically motivated, it almost makes my argument more important. And I say this for at least two reasons. The first is that, as many people have acknowledged in the Q&A and also throughout the discussion, the political polarization in this country is quite intense. And I say this as somebody in a mixed partisan marriage, so I get it, it's there. And many of those divides are based on opinions and ideologies and things that are kind of difficult to counter. But one of the benefits of HIPAA is that it is something with a objectively correct answer. So in some ways, in terms of the many ways that political objections can appear, this one is in fact with mercifully. The second reason is that even if some objections are actually political, I believe that there is going to be a percentage that are not, and a percentage of the population that is subject to influence based on political reasons that could be swayed by facts. And I think reaching that group with factual information is and remains incredibly important.
And I'm going to pose our last question to Professor Landers. The traditional means-tested public benefit programs in the United States have imposed constraints on how program benefits can be used. For example, limiting the types of foods that can be purchased with SNAP benefits or food stamps. Similarly, these programs often imposed lifestyle constraints on the recipients. Are these types of constraints necessary to ensure the integrity of the programs, and are they consistent with the dignity of the beneficiaries?
I would give an unequivocal no, they are not necessary and they are not consistent with the dignity of the beneficiaries. I think that this is relates back to a lot of the issues in the history that Dean Mutcherson's talk raised at the beginning of the conference. I think there's been a long history of benefit programs in the country. I've written about this of trying to limit the recipients to the deserving poor, right? The widow, the orphan, the people who are considered blameless. And even in New England, in colonial times, there was this process of warning out that if a person moved from one community to another, the new government in the community, the government in the new community would warn the person out and say, you are welcome here as long as you can take care of yourself. But if you fall on hard times, you have to leave and go back to your people, because those are the people who are responsible for taking care of you. And I think a lot of the public benefit programs have been structured to try to ensure that the sort of idle beggar doesn't, receive any kind of benefits. And the result of that is that the benefits are too stingy. The average benefit under the Social Security income program, which is the last resort for people who are not able to work and earn an income, is 75% of the federal poverty level. How is that a living wage? The questioner mentioned the limitations on what foods could be purchased through SNAP benefits. I think that's a real challenge. I mean, one of the famous cases in administrative law is this case involving, whether chocolate milk should be on the list of flavored milk should be on the list of things that could be purchased with SNAP benefits. And, there are a lot of reasons it eventually was added back. But it was just a super controlling and very misguided kind of restriction on what the benefits could be used for. There are experiments going on now with SNAP benefits because it was very hard for people during the pandemic to use their SNAP benefits to have groceries delivered. Here we were trying to discourage people from having to go out and that sort of thing, but we made it really impossible for that community to do that because of the structure of the SNAP benefits. So there's an experiment going on in some neighborhoods in Boston where, there's a funder to take care of the delivery charges because those can't be, charged, the SNAP benefits can't be used for the delivery charges. But there are some grocery stores who are now willing to deliver the groceries, to the SNAP, the people who pay using SNAP benefits. So, I think that these experiments, will all show that they're not abused. The final point I will make is that many local communities have been experimenting with just giving unrestricted payments to people on a monthly basis, so that there's a big foundation in Boston that's actually funded by the foundation created by one of the Wayfair founders, actually. But that has got this experiment going in the city of Chelsea, which gives, just basically debit cards, $400 a month to people, and they can use them for whatever they want. And but there's a significant record keeping of what the debit cards are used for. And they're used for things like food, clothes for the children, health copays, so that you can make health visits, because the copays are a big barrier to low income populations actually using health insurance if they have it. And so it's not and people continue to work. And so it's not the case that these very modest augmentations of income are going to discourage work, but they're actually going to enable people to live better lives. So I do think that these restrictions are not necessary for the integrity of the programs, and that they do interfere with people's ability to make choices on how to spend their money the way they need to spend it.
Thank you, Professor Landers, Professor Fowler, and Professor Furrow for presenting today and participating in this discussion. I would like to invite you, if you're able to return later in our event, to participate in our roundtable discussion. I will be posing some questions to all of our panelists, and that will be later this afternoon. At this time, I would like to ask all of our panelists to turn off their cameras and microphones. We are going to be taking a short break, and we will be returning at 12 p.m. Central Standard Time. Thank you. Okay, I'll see you soon.
Okay, welcome back, everyone. My name is Audrey Nelson, and I'm the editor-in-chief of the Kansas Journal of Law and Public Policy. At this time, we're going to begin our panel 2 presentations, which will focus on post-pandemic technology concerns regarding security, surveillance, biometric and location data, and other technology-related privacy implications. Our first speaker is Professor Jacob Ellberg. Professor Ellberg teaches in the areas of health law, healthcare fraud and abuse, evidence, and data analytics, and he's the Associate Director of Seton Hall Law School's Center for Health and Pharmaceutical Law. His scholarship has been published or is forthcoming in the Wisconsin Law Review, Washington Law Review, Utah Law Review, and the New England Journal of Medicine. Prior to joining Seton Hall Law School, Professor Ellberg served with the Department of Justice, where he led one of the largest and most impactful healthcare fraud units in the country. He directed the office's criminal and civil investigations and prosecutions of healthcare and fraud offenses. He has also supervised investigations regarding Foreign Corrupt Practices Act violations, as well as fraud against certain government agencies and programs. Professor Ellberg has launched the District of New Jersey's Data Mining Working Group and spearheaded the office's efforts to utilize data analytics to identify, investigate, and prosecute healthcare fraud offenses. In 2013, Professor Ellberg was awarded the Department of Justice's Executive Office of U.S. Attorneys Director's Award for Superior Performance. Welcome, Professor Ellberg.
Thank you very much, Audrey, and thank you to the University of Kansas School of Law, the terrific group of students that it's been a pleasure to work with as this symposium has approached, and to my friend and former colleague, Professor Peters. It is a pleasure to take part in this really interesting symposium, and I thank you for including me. I'm going to share my slides, and we should hopefully be off and running. So I want to talk today in follow-up to what Professor Furrow spoke about earlier, because Professor Furrow spoke about a number of the areas of opportunity for telehealth. And those opportunities are very real. I want to talk about a different aspect of that. And it is that as we see in a number of contexts, as concerns about fraud rise, concerns about privacy tend to be moved to the side. And currently, telehealth, putting aside all the really positives from some people's perspectives and from the government and healthcare fraud enforcers' perspective, telehealth is viewed as a significant risk of fraud. And that brings with it, potentially, as I'm going to discuss, questions about whether privacy is going to be less of a focus. So as I said, currently telehealth is viewed as a significant risk for fraud. I think that is both right and wrong for it to be viewed that way. And I want to talk a bit about that. Whether right or wrong, though, it is clearly the view of the Department of Justice and enforcers and policymakers more generally. And that impacts the level of scrutiny of telehealth and treatment via telehealth. Happening at the same time is a separate trend, a trend of increased use by the government of data for investigating and prosecuting fraud in the area of healthcare in particular. And as I'll explain, these issues come together and they connect because enforcers see and will continue to see, I think correctly, the use of data as the most efficient and most effective way to combat healthcare fraud generally and healthcare fraud involving telehealth specifically. What's left out of that discussion most frequently, though, and the analysis is the impact on patient privacy. And I want to talk about that too. So let's start by talking about how enforcers are viewing telehealth. Professor Landis talked about opportunities through telehealth, and that was the focus of Professor Furrow's talk earlier today. From an enforcer perspective, there's not necessarily dispute with any of that. I don't think enforcers would take issue with the idea that there are real benefits from telehealth. But the focus from that enforcer perspective, as tends to be the focus of enforcers, is more on what they see as opportunities for fraud. And I want to just highlight some of where we've seen that from the Department of Justice and other enforcers. So this is the fraud section year in review document from 2020. So this is not new, but has only been increasing over the last year or so. And this talks specifically about a telemedicine fraud initiative, that was sufficient or substantial enough concerns about telemedicine fraud to have there be a separately named initiative called out and a focus of this report, and to just pull out a bit from it because the numbers really are substantial. To date, the fraud section has charged 73 defendants involving more than 3.7 billion in alleged fraud loss around the country involving schemes that exploited telemedicine. And so that is how this is, it's characterized from a DOJ perspective. And if you look at other cases and other initiatives of DOJ, $3.7 billion is a lot of money. Just to go a bit deeper though, I think it's helpful to talk a little bit about what we're talking about when DOJ and other enforcers are talking about fraud in this area. What are they talking about and what are they not talking about? Because I want to focus a little bit on the extent to which this is fraud that really is telemedicine specific or not. So in these telemedicine schemes, this is from the same report, telemedicine company executives alleged to have paid doctors and nurse practitioners to order unnecessary DME, genetic and other diagnostic testing, pain medications, without any patient interaction at all, or with only a brief telephonic conversation with patients they have never met or seen. And so that is what we see frequently in these cases, as the driver is not the visit itself, but is instead the suggestion that these visits are being used as a way to then give access to, through prescriptions and authorizations, to other areas where there would be substantial billing. So that was DOJ. Here is HHS. This is HHS talking about their national healthcare fraud takedown and focusing again on telefraud, what they're calling telefraud. I'm saying since 2016, a significant increase in telefraud scams that leverage telehealth services and including telemedicine company executives, medical practitioners, and others. Just to go a bit further, looking at a few press releases. This is a DOJ press release from last year, talking about criminal charges against telemedicine company executives and others with losses exceeding 143 million. And this talks about the cases involve allegedly exploiting expanded policy. So that's what I want to highlight, is this suggestion and the concern from the enforcement community that as policies expand to allow more in terms of telemedicine and these opportunities increase. Obviously, there's a good side of that in terms of access to care, but enforcer concern that leads to additional fraud. If folks exploiting it for sham telemedicine encounters that did not occur, and then bribes in exchange for referral of unnecessary testing where the telehealth visit is what led.
I'm so sorry to interrupt you.
Yes.
We can only see your first slide.
Oh no, well, let me try to fix that, because I've advanced, but let's see what's going on. Thank you very much, and thank you everybody for bearing with me. I guess I will feel less badly about the fact that my slides are not the most visually appealing slides that I've had, and hopefully my explanations have been sufficient. But please let me know if my technological lack of skills catches up with me. Again, thanks everybody for bearing with me. So we're talking about here, we're talking about bribes. Also, just to give a further example, there's another part of a press release talking about, again, exploiting temporary waivers of telehealth restrictions enacted during the pandemic by offering essentially bribes to both be seeing patients who they didn't need to be seeing, and then ordering expensive and medically unnecessary testing and other treatment. So I raise these things to give a sense of a few things. One, the focus from enforcers on this level of concern, and I'll talk about the impact of that in a moment, but also to just give a sense of what they're talking about when they're talking about that fraud, because healthcare fraud is a range of things, some very sophisticated, exploiting gray areas, and other less so. The good news is that this is of a less sophisticated variety. This isn't an issue of gray areas. Professor Furrow mentioned issues of fraud when he was talking about issues that relate. He mentioned issues of fraud, but he also talked about issues of challenges regarding what the rules should be and the regulations should be. This is purely the first thing. This is not well-intentioned practitioners being told, no, that's not appropriate for telemedicine. You're not doing it the right way, or don't have the right approval to be doing what you're doing. This is out and out fraud. So the bad news is that there is a lot of money there. The good news, though, is from an enforcement perspective, is that because this is not that gray area stuff, it can be easier to identify. I don't want to talk about, though, in these last few minutes, the challenge of doing that is that the work involved with identifying that fraud involves increased scrutiny of folks who are getting care in this way. And the potential that folks getting care in this way will be singled out in terms of additional scrutiny, additional review of the care that they are getting, and there are privacy concerns that go along with that. So here, the real answer, what you hear when you talk to folks in enforcement is that data analytics is the way to dig in and identify these issues of fraud. And what that means is we talk about what that would look like is going to be increased scrutinizing of patient level data, not just looking at things in aggregate, but looking at patient level data, and essentially making telehealth care that's going to be looked at more closely. So just to give a brief overview of the type of things we're talking about data analytics, looking at that provider patient relationship. Was that a relationship that existed previously before the telehealth visit is taking place? In some places there are rules surrounding that, in other places there are not. Questions about the dispensing relationship, if there is a relationship between the patient and the pharmacy where they're getting a prescription filled, or the DME provider providing that type of product. Questions about the prescriber, so a doctor where they're prescribing for a patient, questions about their relationship to who is actually going to be dispensing. And it's particularly a focus in areas involving high dollar amounts. For the most part, these are not issues where the money is coming from the visit itself, but instead issues where there are drugs or lab tests or DME or other things, and that's really where the expense comes from. What most of this data analytics is about, though, what most of it is focused on, though, are questions of looking deeply at individual patient relationships, individual patient care. And so what we're talking about here, and there are a whole series of government entities involved, and obviously the same is true when we're talking about private health insurance as well, where there is significant access to and increasingly significant manipulation of and examination of patient level data that is not de-identified generally, and where what's necessary for the government to investigate in this way is to be looking closely at these individual patients, at their series of care, at the diagnoses they have, at what's happening with it in a way that generally we don't see in the healthcare system, but essentially singling out this type of care as one where increased scrutiny is necessary from the government's perspective to prevent fraud. There are echoes, I think, in some ways to the concerns and the criticisms that have especially become pronounced recently regarding and surrounding PDMPs and electronic databases tracking controlled substances prescriptions, and the extent to which that's an area where there's been an increased focus. And similarly there, where we've seen in the opioid space increased concerns about fraud that may be legitimate, but leading to potential concerns about about having a level of scrutiny and a level of looking at individual patients that raises concerns from a privacy perspective. I think we have the same potential concerns here as telehealth continues to grow for lots of good reasons, but there remains significant skepticism about the fraud that may follow with that. Thank you.
Okay, great. Well, thanks everybody. It's been a great day so far. I want to echo my colleague Jake Ellberg's thanks to Jari Peters, our former colleague and still at Seton Hall, and our current colleague in privacy and health and so on. And here I'm going to share my screen now. There we go. All right. So I'm going to talk about really getting into some more granular detail. It's been interesting to see how we've had some sort of very broad discussions and filtering down into some details. And I want to talk about contact tracing apps, which, as we know, were sort of a popular thing at the beginning of the pandemic and became really kind of not very much used and ineffective. And there are a bunch of reasons for that, but I want to talk about some of the privacy and security issues with a particularly interesting to me example in Germany. So, as I said, these were things that were adopted early on. It was one of the sort of places where policymakers thought, technology might really provide an assist to slow the growth of the pandemic until vaccines could be developed. But it really didn't work, and a large part of it was simply the uptake. I mean, it required most of us to be using these when relatively small percentages were, but people were also concerned
and in some ways rightfully so, about the privacy and security implications of whether and to what extent they were sharing health information, either with other people in their proximity or with the government or with somebody else. So in the German example, and I think this was mirrored the debates that were generally going on in the time in various places. The initial proposal was to use the GPS system, and as we know, the GPS system is relatively precise, and it is readily available. Of course, it's something we all have on our phones. And the problem with the GPS system was that the system itself, the architecture of the system itself, really it remains relatively centralized and relatively less secure than the alternative that people ended up settling on, which is Bluetooth low energy. So I'm sure you know on your device, you probably have a Bluetooth antenna, and there are different things that you can do, like, for example, maybe connect to your wireless headphones using the Bluetooth. And so the idea is if you have two different devices, I put my iPad away, but if you have two different devices kind of in proximity, the Bluetooth can communicate with each other and can in some way provide a sense of who is in your proximity and can provide information in that way. And using Bluetooth, there was still the possibility of some centralized solution. So, a central database that would be maintained somewhere of information. But increasingly, policymakers, because of privacy concerns, really started to move toward the idea of a decentralized idea. And in Germany, the policymakers settled on a couple of different kinds of protocols. And one is the decentralized privacy preserving proximity tracing. That's a tongue twister, I guarantee you, DP3T protocol. And that was related to a protocol that's kind of an interesting joint product between Google and Apple called the Google Apple Exposure Notification. And just to show you a little bit of how this works, I have to turn my pen off here. This is a cartoon that the DPT folks, make sure I get this in the right place, put out. And again, this is kind of early in the pandemic. And the idea is to be, kind of be really simplistic about it. There's not a centralized database of all of the information. Users are exchanging information on their phones using keys that are basically encrypted keys. Now, there is some information that is being stored in a central place, but it's supposed to not be specific health information of the individual. So there's the cartoon. And the DPT, as I'll talk about in just a moment, was a consortium of academic researchers early in the pandemic trying to find a kind of privacy forward solution for this. The GAIN framework was Google and Apple creating APIs, and APIs an application programming interface, or pieces of code and protocols that allow sort of one system to hook in and work with another. And this was necessary because DPT was an open source kind of product. And if you wanted it to work on an Android phone or you wanted it to work on an Apple phone, you had to have APIs that would allow this product to hook into Google and Apple. And I will of course come back to the role of these big tech players toward the end of my talk. So the German government agreed to the terms that involve the GAIN framework using DPT3 and commissioned a couple of entities to build out the app. One was SAP, and you may know the SAP name. It's a huge global brand. It's a German private company that provides human resource software and services like that. And the other was a company called DT, which is a private company with a 30% stake owned by the German government. Now, of course, any German corporate form is going to be in some ways more public facing in a sense than US privately traded companies because of the corporate form in Germany. But you can see here there's an effort at a public-private kind of partnership. The framework, the app, when it was finally developed, was entirely voluntary. An individual could decide to install it or not. The devices communicate locally and the information is stored locally, with the sort of twist that there was a database that had to be pinged against in order for the devices to have the necessary information to share with other devices. It included the ability for a user to upload a positive lab test. And in fact, it pinged with some of the labs, or it was supposed to ping with some of the labs that were doing the testing to do this automatically. And it was doing this again with encrypted keys. The server of the labs that were doing this was controlled by the German health authority. And then the way the GAIN framework works and DPT3 works is that it provides a risk score. And the notion is that, you know, you as a user, if you're sort of out and about and you say go into the supermarket and your phone would say, you know, your risk score has gone from green when you left your home to maybe yellow because of some of the potential exposure of other users in that area, or maybe red, you know, if it's a higher kind of exposure. So a number of really interesting legal issues. One was the sort of straightforward privacy issue under GDPR, which of course GDPR is the general data privacy regulation that applies throughout the European Union. And, you know, as we said, these keys are being communicated at least between this central server that is communicating test results. The keys themselves are encrypted, so the actual information in the keys is encrypted, and that would not be PII, it would not be personally identifying information, but there were also IP addresses associated with that communication, which were not encrypted, and IP addresses are PII. So the German government did need to have what's called a legal basis under GDPR to process this data. There were really two possible legal bases that the German government could have asserted. One is consent, to the extent the app built in consent features, and the other is this public interest one. Now, the German government opted to rely only on consent, which was sort of interesting. There were some other EU governments that had similar apps, for example, Switzerland, that had a broader basis, including the public interest basis, but the German government felt that the consent based into the app was good enough. Some groups disagreed, and you know, the issue was never really sort of litigated or resolved through any kind of complaint stage. And really the question was about the specific design of the app. This is the language I'm just going to rush through in GDPR of what consent has to include and whether the users were actually informed that IP addresses were going to the health authority. Now, the other interesting set of issues to me about all this is the IP side of it, because you've got several different protocols and different pieces of code. The DP3T protocol, as I mentioned, was created by this international consortium of researchers. And I'm just going to show you, I got to turn my pen off again here. Where did my pen go? There it is. I'm just going to show you in the white paper that establishes the DPT, the institutional affiliations of all of those researchers. Now, it's not clear to me, and from reading the documents and having some communication with some of the project leaders, exactly what their relationship to their home institution was in terms of intellectual property. And that raises kind of an interesting question for me. The protocol itself is published under an open source license, actually two different open source licenses, which is great. So one is a Creative Commons license for the documentation, and there is a Mozilla license for the code. The Creative Commons license is simply an attribution license, which means anybody is free to use the documentation. Anybody is used to remix it, to make derivative works, to change it. But you do have to give attribution. It is a viral license. You're not permitted to use technological measures, which is a term of art in sort of para-copyright law, to prevent access. And likewise, the Mozilla license is a FOSS, a free and open source software license. It must be royalty free. It is also viral. There are also disclaimers of warranties. The code is as is. DP3T developed its protocol not specifically in conjunction with anyone else. They recognized that some governments like Germany were using the GAIN framework, and in later versions of their documentation, they suggested that there could be some issues with Apple and Google's privacy implementation of their APIs using what is meant to be a very privacy forward framework, and they asked Apple and Google to implement some additional things. One of those enhancements, without getting too much into the details, and this is a drawing from the white paper document, is a way of putting multiple keys out there, some of which are dummy keys and some of which are authentic, which limits the ability of a drive-by attacker to get the appropriate key and then decrypt it. And I'm trying to find out a little bit more from the project designers here, to whatever extent Google or Apple ever took any of this up. And just to note that this protocol, as a protocol, is designed to be relatively wide. It's not a bug that a company like Google or Apple might have to use APIs to implement it. It is sort of a feature of how it works. But it does require trade-offs. There's nothing perfect about it. And you can see there's both security issues and sort of practicality issues. I mean, it has to not totally drain the battery. It has to not use up too much bandwidth. So you're always trying to think about these trade-offs, and you're never going to have perfect security or perfect privacy with something that's actually going to work out in the wild. Now, as to the GAIN APIs, this was really interesting. Google has very developed documentation about it. It also is a Creative Commons attribution license, and the code snippets are an Apache 2.0 license, which is, again, are both open source licenses. There are other terms, Google developer terms, which actually are pretty generous open source terms, but those terms apply as well, and Google can change them whenever it wants to, which is interesting. And this is the Apache license, which is very much like the Mozilla license. So I would say, kind of getting toward the end of my time here, I think there are some interesting questions about this. Obviously, the technology didn't work for some practical reasons of uptake, but that doesn't necessarily mean the idea was entirely a bad idea. I think some of the problems with uptake, and I'll say, I never installed a contact tracing app. I did install an app that my employer in the very beginning of things required me to install to sort of check in before I went into the office, and which I found pretty creepy. But it was what it was. And I did feel, a little creeped out, to use non-legal technical terminology, by contact tracing apps. I think perhaps if I understood this architecture a little better, I wouldn't have felt as concerned about it. But I still think there's a broader social kind of technological question about how people feel about sort of walking around with, getting notifications on their phone about what the status of the people around them may or may not be. So those are issues, but I do think if and when the next pandemic or next public health crisis hits, there are going to be some technological proposals or solutions like this that we might want to look into. But on the legal and policy side of this one, open source licenses are great. It is a little concerning that there are multiple different layers of them, and whether a government health authority, or in the United States, maybe it's an individual state health authority, really understands what they're signing up for and what all those different layers mean is probably doubtful. The Google policies aren't bad, as I said, as they stand. It's a problem that Google can change them whenever it wants to. They are good open source policies. The relationship to Apple is, as far as I can tell, is totally opaque. I don't know, and I can't figure out a way to find out exactly what agreements Google might have had with Apple. I don't know what IP Apple may or may not assert. So that to me is a real problem. The relationship of the employers who were helping to develop this is very unclear. and of course the overall role of big tech. And we did have a little bit of discussion about big tech earlier today. I'll put in a brief plug. Next week at Seton Hall, we're having a really great big tech and antitrust conference. So we're really interested in those issues as well. You know, on the one hand, these entities have huge resources. They can work pretty efficiently. A company like Google does have a significant side that is an open source ethos. We can have public-private partnerships that are great. On the other hand, you know, someone said earlier, do I trust Jeff Bezos? Maybe not totally. Do we totally trust Google and Apple? Maybe not totally. And I think these are some of the questions that we'll have to ask the next time this kind of thing comes on our radar screen. Thanks. I think you're muted, Melinda.
I am muted. Thank you, Dr. Opterbeck. I just realized that during the technical difficulties, we did not introduce you. I apologize for that. So I'm going to turn it over to Josh Sipp really quick. And he is a staff editor for the Kansas Journal of Law and Public Policy, and he will read your bio. Thank you again for your flexibility. Josh, I think you're muted.
Do it that way. Yeah, so thank you, Doctor. Dr. Opterbeck is a professor of law and co-director of the Gibbons Institute of Law, Science and Technology and Institute for Privacy Protection at Seton Hall University Law School. His work focuses on technology, law, and policy, including issues related to cybersecurity, privacy, and intellectual property. Dr. Opterbeck is a certified information privacy professional in the US and Europe, and also holds a number of cybersecurity certifications. Dr. Opterbeck's publications concerning cybersecurity law and policy consider the law and economics of data breach litigation and executive power in cyber emergencies. He recently administered a multi-year project at Seton Hall University Law School that convenes special programs and government working groups on cybersecurity issues. In the intellectual property field, Dr. Opterbeck's work examines issues such as settlements and Hatch-Waxman litigation, cybersecurity policy, intellectual property restrictions on essential medicines in developing countries, open source biotechnology, patent damages reform, and the interaction of law and social norms concerning music file sharing. Before his academic career, he was a partner in the Technology and Intellectual Property Law Group at McCarter & English, LLP. Thank you again, Dr. Opterbeck.
Thank you, Josh.
And at this time, we will turn it back over to Professor Hellaby. Sorry for the technical difficulties. Thank you for joining us.
Yeah, I'm not entirely sure. It's yours to apologize. It might have been me. Can everybody hear me okay now?
Yes.
Okay, excellent. Let's see if I can also successfully share my slides. Well, hello, everybody. Sorry, it's been a little bit between the introduction and my presentation, but hopefully that won't detract too much from it. So Professor Opterbeck did a sort of really erudite and effective job of addressing one of the technologies that's emerged in the course of the COVID-19 pandemic. I'm going to try to give you a kind of broad survey of what those technologies are and some of the privacy issues they've raised. His presentation sort of anticipated that there aren't a lot of good legal solutions. I want to cover what the solutions look like in the United States, sort of the extent to which GDPR, and I'll discuss it in a little bit different way than Professor Opterbeck did. And then maybe for the first time, I'll raise the issue of an international pandemic treaty, which is now at the negotiation phase at the World Health Organization, the extent to which sort of health data privacy has been discussed in the course of that treaty, and sort of what so creepy is right. Sort of a lot of it makes us feel creepy, and the question is what to do about it. So just to recap for everybody, so COVID can be spread in a couple of different ways, but the most important is just through sort of coughing and the spread of aerosols in the air. It can live for a couple of minutes in the air. It's one of the reasons it's so infectious, and it's one of the reasons that Omicron specifically was so infectious, is because it became really adept at being spread in this way.
And for these numbers, by the way, are from the alpha sort of phase of the pandemic, right? So that's the beginning months of 2020. So that, sort of people became symptomatic, they became obviously symptomatic. And at that point, it was for the most part too late for traditional public health intervention tools, right? So traditionally speaking, when there's an infectious disease outbreak, we try to identify those people who are infected, we try to isolate or quarantine, we try to contact trace to see who else is infected and how we can prevent the disease's spread. And all of those traditional tools in the COVID-19 context, and not limited to COVID-19, right? So this is the same thing that happens for SARS-CoV-1, so the outbreak in 2002, 2003, for influenza. If sort of you ever listened to Tony Fauci talk about this, this was always his nightmare, right? So an infectious disease, it's respiratory in nature and easily transmitted between people, and that's exactly what SARS-CoV-2 is. To try to undertake contact tracing in the context of COVID-19 would have been a mammoth undertaking, right? So it would have required something like 100,000 to 300,000 new workers, $3 billion to $12 billion in spending for that task alone. The United States government, even if it would have done all of those things, was so behind the ball when the threat emerged that it might not have made that much of a difference. Although when you look at the sort of 11 or 21 or $31 trillion price tag of COVID so far, this actually looks like it might have been a pretty good investment. But the whole point of my presentation is that digital alternatives to traditional contact tracing are what governments look to. So Professor Opterbeck went into this a little bit. So just to, kind of review. So governments worldwide, state governments in the United States sort of looked into phone-based technologies to see if they could detect COVID through a number of means, right? So that included call data records, it included GPS location data, but probably most promising was Bluetooth, right? The idea that we could sort of with two phones that had, at least in the United States context, voluntarily downloaded an application using Bluetooth, we could identify lots of important information, who was infected, how close they were near somebody, sort of we could alert those people who had downloaded the application quickly. I think a lot of you have probably seen this, this alert on your phone. This was the hope of what could be accomplished. It of course was rolled out a little bit too late. But the idea is, if you take a look on this diagram, so let's talk about subject A, who's maybe in New York, not symptomatic at all. On day 2, it has a fever, right? And we can immediately sort of identify who's been in close proximity to that person, and maybe alleviate some of the burden of contact tracing that we would traditionally think of in an epidemic or pandemic context. As Professor Opterbeck mentioned, sort of that some countries, so for example, Singapore, during the course of the Delta peak, actually required these applications as a matter of law, right? So coerced citizens to either have the application or an alternative sort of pass ID bracelet if they didn't have a phone. So that was most of the elderly population in Singapore. But as a purely voluntary matter, no jurisdiction in the world reached the threshold that would have been necessary to actually take the place of contact tracing, right? So the estimate was about 60% of people would need to use that app for it to be effective. You never got anywhere near that in Singapore, and in Australia, and Iceland, even countries where the kind of creepiness factor of the population is probably a little bit attenuated. Now, of course, we have the same kinds of phone-based technologies that are used for, the shorthand phrase we're using is vaccine passports. That the way that they actually function varies quite a bit. But the idea is that your phone is a form of sort of personal health identifier for an intervention you've received, right? So you've received a medicine that other people haven't, and it distinguishes you, right? It's personally identifiable health information in a very transparent and collected way. As I mentioned, these have been rolled out in lots of different ways across the world. So the PRC, the People's Republic of China, has probably the rollout that has concerned those who are concerned about privacy the most, right? Which is essentially sort of you get a green if it's okay to travel somewhere and you've been immunized. You get a yellow if there's reason to worry. But there are more than just anecdotal reports of people who are political dissidents or who have spoken in criticism of the government receiving yellow for reasons that don't appear associated with their vaccine status or with the risks they might pose for spreading COVID-19. So besides cell phones, which is where a lot of the research has been, so there's also sort of wastewater sampling, or as it's normally called in literature, wastewater-based epidemiology. It is exactly what you think it is, right? It is sampling people's poop because COVID or SARS-CoV-2 actually shows up in feces in a way that is sooner than most symptomatic infection, right? So it can give you a 1 to 6 day head start, and in some ways kind of miraculous as an early warning system for symptomatic infection. There are lots of concerns about this, right? So wastewater isn't individually identifiable for purposes of DNA sampling in the ways that you might have think of like a cheek swab, but you can sort of start to ascertain and put together community characteristics, right? And you can also detect things like illicit drug use, right? So the fear with wastewater sampling is less about the way that sort of individually identifiable information might be sort of disclosed, or the integrity might not be maintained, and more about community stigma or how communities sort of protect themselves. And unlike cell phone-based technology, there is virtually no meaningful law in this area, right? So what are the limits of what either companies or governments can do when they're collecting, sampling, and using the information that's taken from a community pool, right? So the limited number of Fourth Amendment cases in this context in the United States, you'll probably be unsurprised to learn, suggest there is no expectation of privacy once you have sort of done your business and flushed it down a municipal sewer. That makes sense so far as the jurisprudence go, but now that we're seeing this technology deployed on a far wider basis, it's going to be important to start to fill those legal loopholes. To give you just a little bit of a, kind of a sort of noteworthy example in this field. So if none of you have heard of Giglio Island, it's this island off the coast of Tuscany. There were a couple of symptomatic cases that occurred there kind of at the peak of Italy's pandemic. The fear, of course, was that in a 1,400 person island, it was just going to spread like wildfire. Most of the residents of the island are elderly. As it turned out, it did not. And nobody can really figure out why. Everybody is pretty much in close proximity. There's a theory that maybe it's the purity of the air, right? So there's a relationship between air pollutants and the transmissibility of SARS-CoV-2. But there's a strong possibility that it literally is a genetic anomaly for residents of the island that just made them less susceptible. Now, that's great for them in this context, but you can understand the implications for once you start to identify community-wide or population-wide genetic traits, how it could lead to stigma or discrimination, the selective use of quarantine or isolation. And so that's the concern with sort of the deployment of wastewater-based epidemiology technologies. So drones were used for many purposes over the course of the pandemic. We can think of them in sort of really beneficial ways, right? They can deliver food and medicine to places where sort of real people either can't get to, or it's very hard for them to get to those places. And we can think of them in again, I like Professor Opterbeck's sort of vocabulary here, creepier ways, right? So they can sort of fly over populations to make sure that they are adequately socially distancing. We can also sort of put them right in people's faces to take temperature. There isn't really an effective way to prevent the same drones from taking your temperature remotely, from sort of analyzing, your facial characteristics and storing them for purposes of later police surveillance. And that's the big problem with all of these technologies, is that there isn't a meaningful way, or at least I'm not aware of a meaningful way to truly segregate the public health use and collection of the data from other purposes, either from businesses or from governments, right? So Professor Opterbeck has mentioned the opaque relationship between Google and Apple in the context of developing applications in the United States, sort of is where I'm most familiar with it. Clearly it occurred elsewhere. And so you had these cases where, police would use information gathered from public health applications for purposes of gathering evidence or contacting witnesses or otherwise pursuing, prosecutions. In jurisdictions with robust rule of law sort of traditions, maybe we don't feel so worried about that. But the reality is that these technologies were deployed in lots of jurisdictions where, strong protections of individual rights or sort of rights to a fair trial or rights against the state in a criminal context aren't particularly well protected. And there's, sort of, you don't need many bases for paranoia. Here's another just sort of pearl in case you all haven't heard it. So this is sort of a Dean Koontz book in 1981 with like kind of eerie, closeness to the events that actually occur. But I think in general, people have a suspicion that both governments and companies are probably collecting more information than they should about people and using it in ways that if people truly knew, they would be wary about. There is no meaningful national law that addresses this, right? So, Professor Fowler did this, I think, really effective overview of what HIPAA does and does not do. HIPAA is extraordinarily limited to the types of custodians that collect personally identifiable health information, and just as constrained in what you can do should a breach occur. There is the Privacy Act of 1974, which does create some limits on what information government agencies can collect about you. But if you ever read through the statutory exceptions, they effectively swallow the rule. The Federal Trade Commission is the agency in charge, charged with enforcing the law. For those of you who have either worked for the FTC or know about the FTC, really wonderful, committed people work there. The reality is that Congress has essentially declawed the agency in the mid-1980s. It has very limited capacity to set broad rules, and it's understaffed and under-resourced. So anytime you see a new law that proposes the FTC as the primary enforcer, at least I am wary based on what it is actually able to do with its people and its mandate. That leaves state law, right? And state law isn't just sort of patchy, but it's also subject to various preemption doctrines because the federal government hasn't acted yet, but it might. And it's in fields that are pretty clearly committed to the federal government should it choose to act. So I just want to walk through a couple of the laws that have been proposed in the last Congress and the current Congress. One that I'll generally characterize as sort of like GOP favored is the Consumer Data Privacy and Security Act. And it gives individuals control over their own data. It's largely oriented against businesses, not against the government. And there you can see on the last bullet, it makes the FTC and state attorneys general the primary enforcers, right? So it seems like if you really cared about this issue, you would want individuals to also be able to enforce the law. That isn't one of the provisions of the Consumer Data Privacy and Security Act as it's currently posed. This law in its current form and in the current Congress is unlikely to pass. And what is more likely, although it seems to be becoming more distant day by day, is the kind of Democratic proposed alternative, which is the Public Health Emergency Privacy Act. Again, what it says is that it is going to require that public health information collected for public health purposes only be used in the context of public health, but it really doesn't have an effective or like toothful mechanism to do that. It's concerned with voting rights, which almost ensures that it won't become law and as the composition of the current Congress goes. And it also does provide for individuals to enforce some of its provisions. So in that sense, it's more likely to be a little bit more effective. All of that runs against, and we don't need to go too far the rabbit hole on this one, the Supreme Court's recent standing jurisprudence, right, which suggests that people who have these kind of abstract digital injuries to reputation or sort of a breach of your privacy aren't actually justiciable in federal courts under Article 3. So there are real questions about whether there can ever be really meaningful statutory approaches to this problem. And by the way, only half of the states would allow these kinds of injuries to be adjudicated in their courts either. Professor Opterbeck mentioned the GDPR. So far as I've seen in the literature, the GDPR's approach to this issue was probably the most effective, right? It's pretty principles based. The approach to consent taken by the German government is an interesting one. As you can see, there isn't at all a consensus that represents consensus within the meaning of the law. And most importantly, the GDPR doesn't apply to member states when they are undertaking essentially law enforcement functions. So as you saw, sort of the German government can sort of both be bound by the GDPR and sort of undertake police surveillance with the public and health information that it collected. And there are some of the provisions of the GDPR that would be relevant to this question. And I think I really just want to, as a very last note, I want to mention the pandemic treaty. That's where I do a lot of my work. And so the current proposals for a pandemic treaty revolve around equity in access to medical interventions. That should surprise no one. But I would say even more than that are sort of provisions to make data sharing more robust and more expedited. All of that is going to run up against this issue, right? Or it's going to run up against this issue to the extent that people care about it. So people care about when information is collected about them. They care about the way it's going to be used either by companies or by governments. And in the context of that treaty, it's just unaddressed, which means the treaty's chances of being truly socialized and made functional, among the member states, the World Health Assembly, which is the governing body of the WHO, seems really, really minimal. And so I wish I could end this with something more. I feel like it is a little bit more optimistic than Dean Murchison's sort of keynote, but not much, right? I don't know that there are good solutions here other than sort of, people becoming really active and sort of starting to reach out to their own legislators on these issues, and probably state legislators at that, given the way that things are working in this country. So I'll end there and really look forward to the conversation.
Thank you, Professor Helleby. At this time, I will ask Dr. Opterbeck and Professor Ellberg to join us for the panel 2 discussion. And I will go ahead and turn to a few of my questions. My first question is for Professor Helleby. What international agreements might address the gathering and uses of data gathered for purposes of public health prevention and response?
Well, there really are none that exist. So a lot of people on the call and in the audience are probably familiar with the United States EU Privacy Shield, which essentially it created a kind of mechanism for reciprocity as between the EU and the US. The European Court of Justice struck down the shield as being insufficiently protective of Europeans' rights to protect their individual information. So we don't even really have that anymore. But I would say, I really do hope that something addressing privacy would be included in the pandemic treaty. I'm pessimistic that will come to pass. And so I actually think that this is it's a much more promising route, right? This idea of either bilateral or trilateral or regional approaches to mutual regard. And a lot of you are probably familiar with sort of like, Five Eyes agreements. So governments do this currently, but in the opposite direction, right? Sort of they give each other the right to spy on each other's citizens. But you can sort of hope that something that would be privacy protective might also be a possibility.
My next question is for Professor Ellberg. As there is increased discussion of government surveillance and issues of privacy in other contexts, what do you foresee happening in the area of government investigations of healthcare matters? Do you think we're going to see limitations put on what government investigators can do?
I think, frankly, I don't. It's interesting, but it's an area where it just largely escaped scrutiny, and folks at this point, there's just not a level of attention to it that it has become an issue. And if you think about even what's going on the opioid side of things, where there now is really a substantial movement pushing back on enforcement, it still hasn't changed what's going on. So we'll see. I could be wrong, but I think at this point, it looks like it's something that is going to continue. And from my perspective, if that's going to be the case, it should at least be, as folks are thinking about what makes sense as an expansion and what to pursue, understanding that that's a likely cost of doing so.
Dr. Obderbeck, what are some ways governments can develop apps and other technologies relating to public health crisis without becoming bound to big tech companies?
Thanks. Yeah, well, kind of like Professor Halaby, I'm not sure there are great answers. I think the public-private partnership is useful. We're leveraging sort of a kind of almost infrastructure in those industries. But I do wonder, you take the German example, for example, the open source community is pretty robust. The DPT3 protocol, is kind of developed by researchers, and I do wonder if there can be sort of more recourse to that, or more norms that are established that don't have to be as tied, or at least can be more transparent. I mean, I do think the Google, the GAIN framework, Google documents are relatively transparent, but it's the Apple piece that concerns me. So maybe it's more just a matter of the transparency of these kinds of projects. And of course, I sort of flagged the antitrust issue, and that's kind of orthogonal, but kind of related in a way, because it's the size and power of these companies, and to what extent they're being regulated in that regard, that makes this really interesting.
Thank you. And if there are no other questions from the audience at this time, we can go ahead and move forward to our roundtable discussion. I would like to invite all of our panelists from today to participate. And during the roundtable discussion, we're going to discuss the disproportionate impact of the pandemic in racially marginalized communities. I would like to welcome Professor Terry Dobbins-Baxter and Professor Thomas Williams, who will be leading this conversation and who have authored the questions we will be addressing. Professor Baxter practiced in the litigation and appellate sections in the Houston office of Locke, Liddell & Sapp, now Locke Lord LLP, for 5 years before joining the faculty at St. Louis University of Law School, School of Law in 2002. In 2013, Professor Baxter joined the University of Tennessee College of Law, where she teaches torts, constitutional law, secure transactions, and a family and privacy seminar. Her scholarship focuses on family, privacy, and related constitutional issues. While at UT, she has served as Associate Dean for Faculty Development and Acting Associate Dean for Academic Affairs. Welcome, Professor Baxter. Professor Williams is the supervising attorney in the Duke Law School Startup Ventures Clinic, as well as the director of the JD-MA in Bioethics and Science Policy Joint Degree Program. In the Startup Ventures Clinic, he works with students to represent North Carolina-based early stage for nonprofit and for-profit and nonprofit entities. His academic interest in the startup area is focused on access to economic independence for normally marginalized groups, including disadvantaged youth and children and women and minorities. In his role as the director of the JD-MA program, Professor Williams helps to mentor and guide students through the 3-year joint degree program. In the field of bioethics, his work is focused on research ethics, clinical ethics consultation, and body as property. He is also the program director for Duke Engage Washington, a summer civic engagement program focused on the intersection of science and policymaking. Welcome, Professor Williams. So I would like to start off by addressing my first question to Professor Baxter. The COVID-19 pandemic has brought social and racial injustice and inequity to the forefront of public health. One of the most disturbing aspects of the COVID-19 pandemic is that it has disproportionately affected racial and ethnic minority groups with high rates of death in African American, Native American, Latin American, and Alaskan Native communities. Can you please discuss why the pandemic has had a disproportionate impact in racially marginalized communities?
Yes, so I think one of the things that we've recognized is that these racial health disparities existed before the pandemic. And so it's not as though the pandemic came along and created racial disparities. Instead, it exacerbated existing disparities. And I want to point out that a lot of these health disparities can be traced back to legal frameworks, laws, historic racism, historic segregation, all of these factors that have led to some of these disparities. And in fact, I think, tend to blame people for their own poor health. We tend to believe it's all because of poor choices. If we just ate better, if we took better care of ourselves, if we did things, if people in these communities behaved as they should, then they wouldn't have these disparities. But in fact, there's a lot of research that has shown that the disparities aren't related, much of the disparities aren't related to behavior, but instead to structural conditions, including racism, including the stress of perceived racism. So people who live in communities or who in their daily interactions perceive that they're being discriminated against have higher rates of stress, have higher rates of many illnesses, and that's even if you control for things like education, for other factors that tend to have an insulating effect for other populations. So several people talked about the higher rates of maternal and infant mortality, and there's research that shows that those rates don't correlate with poverty or lack of insurance, that they're higher even for people with advanced degrees, with higher income and things like that. So I think that the first step is why were there pre-existing racial disparities? And a lot of that has to do with historic racism, historic discrimination, and the ongoing reality of dealing with a community that often still discriminates in ways that are harmful to health, including in the healthcare system. There's still persistent misperceptions about particularly Black people, that we don't feel pain the same way, that we have thicker skin. These are attitudes that they found among medical students in recent years, so that some of these perceptions are leading to health disparities before the pandemic. And then after the pandemic, because of the already higher rates of illness and lack of access to healthcare, when the pandemic came along, they tended to hit, as several of the panelists have talked about, people who are in lower income jobs, people who have to travel on public transportation, people who can't socially distance. And then once we have the higher rates of illness, the higher rates of death, that also contributes to higher stress, which contributes to higher rates of illness. And so the disparities that we've seen since the beginning of the pandemic are building on disparities that have existed for a much, much longer time.
I'm going to address my next question to Professor Williams. How might community rights to privacy overtake or at least become equivalent to individual rights to privacy in the era of big data? Does the way data is collected, stored, and used in healthcare require a redefinition of the substantive and normative construction of privacy? As a corollary, are there areas and context in which removing some components of privacy might be necessary to meaningfully highlight inequities and or achieve greater equity, whether structurally and individually? And if so, how do we approach that discourse?
Thanks so much for the question and for having me. And I think I'll echo everyone's gratitude for putting this together. And I think we all recognize the work that it takes. I think through the course of the day, I've been thinking a lot about how dynamic privacy is, whereas we often talk about it and think about it as quite flat and static. But that it really is like your privacy rights and interests and the way that you view them is really dependent both on your position and some of the intersectional components that we heard Professor Mutcherson talk about, and that means things may shift. And so in the course of the day, I was thinking a lot about the incursion of privacy rights, but thinking too about who those incursions serve, who is collecting data and for what purposes. And that if you have different answers to those questions, it can really realign the way that you think about privacy, and who should be surveilling and how they should be surveilling and why. In hearing Professor Baxter's comments, I was also just thinking about, the idea of that stress is also linked to being surveilled. And so that surveillance based upon living in a Black body is the thing that is causing the problems that then become relevant in thinking about healthcare. And so if we're surveilling folks within healthcare structures to actually provide them benefit, to return something to them in the structure of the research we're doing, rather than to serve other populations, to create treatments that they don't have access to, then we need to be having a really different conversation from one in which we're simply usurping from communities data and information in efforts to not only perhaps not serve them, but also to relegate them and to reinforce norms that exist. I think over time, one of the dynamics of privacy is that it has to shift with technological change, with the insights that come from that. I was really taken in thinking about Professor Ellberg's comments around the idea that part of physician oversight in fraud and abuse requires patients to allow some incursion into privacy, and how we might relate that to thinking about health disparities and monitoring of care as an incursion that also reflects and shifts privacy rights of patients in understanding their care, but that may be really focused on understanding what is happening in the dynamics that they experience with providers, and that attempts to serve them. And so then what do those consent structures look like, and what are we thinking about? So I'm really taken with thinking about the dynamics of privacy, which I think is also, I think to think about Professor Fowler's comments, it is sometimes can really be lost in the narratives that we create around privacy and how they are reinforced. So I think there's a lot there to think about how we align privacy, and does it serve individuals versus groups, and when. And so maybe I'll leave it there and perhaps see what others think about some of those comments, and if they align or if they want to push back.
Okay, I will go ahead then and move on to my next question. This question is also directed for you, Professor Williams. Is surveillance a predicate to creating meaningful arguments for and access to the social safety nets required in a pandemic era? If so, what does it mean about the connotation of surveillance and the structure of systems and collection of data not required of those with more robust financial needs?
Yeah, I mean, I think this follows up with Professor Lander's comments and her work, which is that we've made it predicate, but I don't think it's necessary at all. We can provide safety nets that don't require the heavy surveillance that we have created, which has included drug testing, has included proving that you're trying to find work, all these systemic kind of components of surveillance that folks have been led to believe is a necessary component. And so I think that is one of the broken pieces. At the same time, I was really taken with one of the early questions in the first panel around the idea that perhaps Native Americans and Alaska Natives are really quite overlooked, and that at some level surveillance serves these communities to reinforce the anecdotal evidence they have around how the world works and how systems, especially in healthcare systems, which we're talking about today, are filled with bias that we may not easily identify, but that we can find if we decide to, but to actually add credence and kind of bona fides to the complaints of those communities that will be overlooked when it is anecdotal.
And my last question, I will direct at Professor Baxter and Professor Williams, and then I will open it up to all of our panelists for discussion. We all have a part in helping to prevent the spread of COVID-19 and promoting fair access to health. As professionals in the legal field, what steps can we take to fight racial injustice and inequity, promote fair access to health, and address racial health disparities? Let's start with Professor Baxter first.
So I think one of the things that I found in talking to students is, particularly as a law professor, there's a role that I can play in educating them about how the law has functioned to create some of these disparities and perpetuate and sustain the disparities. Because I think otherwise, we all go in with our own biases based on our own experiences or lack of experiences, particularly with communities of color. So often what students come in with is stereotypes, right? Or stories or anecdotes about how other people behave. And I think it's very easy to, like I said in my initial comments, it's easy to blame people for their own health disparities and say, well, this is just about personal choice. And so, you know, if we give people better access, if people would just get better educated, if they would just get better jobs, that'll fix the problem. And they don't take into account the role that the law has played in creating these disparities and perpetuating and sustaining them. And so part of what I think we can do as a legal profession is do a better job of educating people about the law in all of its complexities and understanding that, you know, the laws don't exist and aren't created in a vacuum, and they don't function in a vacuum. They affect people in different ways, and that the legal structures have contributed to problems in ways that we probably don't understand. And as lawyers, we don't see the research from public health authorities that talk about the fact that these disparities are not necessarily linked to these indicators like behavior, like economic status, like education. And so doing a better job of I think Professor Landers talked about better science and health literacy, right? And some of that I think also needs to be passed on to our law students and to lawyers and to educators, so that when we make these decisions and we push for and advocate for policies and for laws, we're doing so with a better understanding of their effects and understanding of the problem that we're actually trying to solve.
Oh, I'll go ahead and jump in, sorry. You know, I think I echo a lot of that. I think we have roles, especially as law professors, to think about how we create advocates, how we train them to look at problems. I think, you know, from my seat, especially connected to the master's in bioethics, to think about how we can approach problems in an interdisciplinary way, and the ways in which lawyers actually absolutely need to be engaged with their colleagues in the sciences, in the humanities, in the social sciences, to inform their work and their approaches. And that can be, as I'll say simple, but it's not simple at all, science communication, and how we message and how we think about our audience. But also, I think there's room for all of us to be advocating for better baseline educational systems, so that folks understand and are able to engage in the world in meaningful ways, and that we don't have wide disparities in understanding, in folks' ability to understand an informed consent document or a contract of adhesion that you click through when you go onto a website. And so you can actually educate yourself about what is happening with your data so that you're making informed choices around it, so that you understand the regulatory regimes in which you operate, and have a sense of how you can then navigate that world, not just as a lawyer, but for everyone who is trying to figure out how to live in the world and understand privacy.
Well, we have a few minutes left if anyone else.
I would just jump in. I guess I would just jump in to add to the terrific comments that we've had thus far on this topic, just to make maybe a broader point, which is, you know, I think it's critically important to be teaching about issues of disparities when we're talking about these specific issues. But I think there's also important work to be done more broadly. When you think about the healthcare system, I think about a lot of folks who are well-intentioned and well-meaning and who don't intend to be perpetuating problems, but where folks, I think, have gotten better and better at where they've learned about a disparity and where they've been educated about a disparity, saying, okay, I've learned about that, I care about that, I'm going to try to do something about that. But it only is within that where they've been educated about it. So I think there's important and really challenging work to be done to say, all right, well, this is an issue where I don't know anything about there being disparities, but I should give some thought to whether there are. Because it seems likely, given what we find when we really look into things, that there will be. So having that be something that people, center and think about more frequently, including in areas where it doesn't jump right out at them, where it's not obvious to them that it's an issue, I think is something that hopefully can be done. For us, that's taken the form of trying, not only to have courses that are really focused on and devoted to such issues, but trying to in courses where people's initial reaction might be to say, hey, that's not what this class is about. To say, all right, let's do some extra work and figure out if there are issues there, and hopefully change people's thinking through that.
I think you're on mute.
Yeah, I think it's important as law professors also to, in any course you teach, try to develop in your students and in yourself, of course, a sense of empathy. So I come from a blue collar working class background, and my aunts and uncles worked in meatpacking in South Dakota. So when I teach torts, I try to give a very strong picture, including YouTube clips of what it's like to be on the floor of a packing plant. Have you ever killed a chicken? Have you ever gutted a pig? It's a culture I grew up with. What's it like to be immigrants working in this industry? And how do you feel about what they're going through? That, you sort of, a lot of law students come from a privileged background, and I think they need to be shaken sometimes to understand the world of disparities and what it feels like and what the law can do to fix it.
I think that's a really excellent point, Barry. I mean, I grew up, I remember when my grandfather didn't have indoor plumbing in his house on his farm in central Illinois, right?
Yeah.
But they moved in 1960 and they got indoor plumbing, so it was okay. But so I think that explaining, how everyone doesn't come from with the same kind of experience growing up is very important. Also, I think what I say to my students is that there's no constitutional right to buy cheap stuff and to make as much money off of your business as you can humanly do without any kind of interference with or any societal obligation. Because, every cheap pound of chicken that we buy in the grocery store or the vegetables that we eat are at the expense of workers who are not well protected in the current economy. And that should be morally troubling, as we go about our lives, to think about how we can make that situation better. And then the last thing I wanted to say is that the thing I think that it's very important for everybody to recognize is that, there are all of these structures and institutions that we have, the laws that have created these situations we've been talking about today, are choices. They are conscious choices. They are not the only way to go about doing things, and that we don't have to accept things as they are, because there could be other ways of trying to, structure your government, have different rules about how the United States Senate operates. I mean, like all of these things that kind of, are constraints on progress right now are conscious choices, and we could be activists for, sort of enlightening people about how to make different choices about those structures.
Just to follow up on Professor Lander's points, I think often in the classroom, I'm somewhat shocked by the failure of imagination to reimagine a system that doesn't hold the defaults that feel familiar. And it's real work to push those boundaries. And for students, especially law students who kind of like systems and rules, to step into the possibility that part of their work may be reimagining, not simply learning, and creating and structuring new systems that account for far more. And so there's a lot of work to be done there. And would just also echo, we've all got to be cognizant of the real variety of backgrounds that we bring to the table and provide space for them. I just saw a great New York Times film piece about chicken farming and about, right, at some level, the high cost of cheap chicken. And those folks are lost in the dialogue of thinking about your food. And so it's about peeling back layers and looking to Professor Lander's point at the whole system that results in the chicken in your grocery store. And so thank you for those comments, and thank you for sharing space with me today. I'm pleased to be a part of such a tremendous group.
I'll just say really quick that I think it's really easy to get depressed and say the problems are too big. And so I really like your point about helping them expand their imaginations about what we can do, because I talk a lot about what's wrong with the law, but the law can actually change and can fix some of these problems. We have to think about and we have to understand. And I like the idea of encouraging curiosity as well. If nothing else, if I can convince students that you should go in thinking there's information I don't know, and start expanding your before you start to come up with solutions, make sure you understand the problem, because I think that narrow understanding of the problem leads to ineffective solutions that leave a lot of folks completely out of the conversation.
Can I give just one example of that? So, and this is what Professor Williams was talking about as well. Professor Williams mentioned, the work requirements, for the Medicaid program, for example. But this is there's one recent case which has kind of a good outcome with respect to that, because when the Arkansas in particular work requirements were challenged, first HHS approved them, and then that approval was challenged. The DC Circuit looked at the Medicaid statute and said the statute is about healthcare for low-income people. It doesn't say anything about encouraging them to work or getting them to work, and therefore you can't have work requirements as a part of this program. And so that's an example of how you can use the law to try to push back at some of these overreaches.
I think I'll just add that I think often even I assume that the systems in place are forever systems and not created out of like historical anomaly or a specific moment in time. And so realizing that things have not always been the way they are, I think is connected to that imagination question, because it simply is what appears to you. And if you don't look under the chicken, then you think that it is as it always has been, and there is no room. But really, we have had all kinds of tremendous moments of shift and change. And I kind of hold on to the hope that maybe the pandemic at some level will be that thing that many of us hope that it was or can be.
Well, thank you so much, Professor Williams and Professor Baxter, for leading this very important conversation.
Thank you for including me.
Thank you. Thank you for your thoughtful commentary. And thank you to all of our panelists for joining us today. Thank you to our audience. And before we conclude, I would just like to quickly remind everyone that scholarship associated with today's symposium will be published soon in an upcoming issue of the Kansas Journal of Law and Public Policy. And the recording of today's symposium will be posted on the KU Law YouTube channel, so please feel free to check that out. Special thanks to Dean Mutcherson for her keynote speech today, and thank you, Professor Peters, Nay, and PrivacyPraxis for all of your help in planning and co-hosting this symposium. Thank you, everyone, and have a wonderful rest of your day. Bye-bye.